Can we do on Friday?
Tomorrow?
Yes.
They are for listing of
What motion matters?
motion matter.
Tomorrow.
My lord, item number 27. May fix it this matter after vacation.
27.
Das Gupta, sir.
Right, item 27. You are making a mention on whose behalf?
Petitioner.
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 Item 27.
I'm
Yes.
referring for Astronomy 1 and 2, my lord.
Any objections?
Objection, my lord, the another writ petition by the same council, petitioner is pending, my lord. WPC 5029
No,
2023.
For the time being, we are adjourning it. On
Yes,
the
my
day
lord,
that
and
you
maybe-
make a mention.
Maybe take along with that, my lord. Same matter.
Same matter.
My lord, there they have challenged one notification whereby, my lord,
No, Mr.
there,
Let the matter be listed in January.
my lord.
Then you make a prayer.
Yes, yes.
Matter stands before to be listed on. uh, Ninth of January,
My lord, that another matter is fixed on 21/1, maybe on 21, my lord.
21,
Yes,
all right, 21st of January.
my lord, oblige.
On the request made by the council on behalf of the petitioner, Mr. G.K. Das,
Astronomy 1
as per the respondents, 1 and,
Mark.
yes.
Item number 14, I'm saying for adjournment, Lordship, and on behalf of the respondent.
Item 49 on the.
14, Lordship, 1-4.
Item
14, Lordship,
14
Lordship,
on the request made on behalf of the respondent.
Lordship,
Matter stands deferred to be listed after 2 weeks.
Lordship.
Yes.
May please.
Obliged, Lord.
Have you informed
Yes,
the others?
yes, Lordship, I have taken consent, Lordship.
May please, Lord.
Yes.
My lord, I beg to mention for listing in motion, my lord.
Motion tomorrow. Yes, tomorrow. Yeah.
Most of them.
Therefore, listing for admission, lordship, after vacation, any date, lordship.
21st of January. 21st January.
My lordship, I beg to mention item number 12, my lordship. I am on behalf of B. Purukaisto, my lordship. We'd like to withdraw this matter with liberty.
Item 12 on the request made by on Mr.
TK Day on behalf of B.
TK,
TK, T for Tamil Nadu, TK Day.
TK Day. On behalf of Mr. B. Purukaister, publish on instructions of the writ petitioner does not wish to press the petition any further. Accordingly, the same stands dismissed on withdrawal with liberty. Interim orders, if any, stand vacated. Anyone for the respondents? You have informed the other side?
Deeply obliged.
If I may, Your Lordship, I beg to mention listing of a writ petition. It was filed on 28th of November. So, Lordship, if it may be listed before the vacation.
Motion,
Admission.
admission matter. Admission or
wait.
motion?
Lordship, it's a family pension matter.
We are asking you on for admission. Is it a fresh matter or a
Fresh
old
matter,
matter?
Lordship. Fresh matter.
Fresh matter.
Yes.
All right, tomorrow.
Okay, Lordship. Highly obliged.
May I please, lordship? My lord,
Yes.
petitioner, my lord, the for regularization and my lord, minimum
Motion,
scale of pay, my
admission.
lord. Admission, my lord.
Admission will be in January,
My lord, there-
21st,
There is an,
21st January.
already, my lord, they have issued an executive order to enforce the petitioner sign undertakings. Otherwise, my lord, salary may be stopped, my lord.
So we can't have it by these 2 days. We'll have to be in the, after reopening.
My lord,
Huh?
my lord.
So
7th
reopening,
of
we are giving you a
January,
date on 21st.
7th of January, my lord.
There are already many
They
matters.
have, my lord, maybe stop, my lord.
How many matters?
One matter, my
All
lord.
right, 7 January.
Obligement.
I beg to mention, the I is filed, my lord, only for fix a date of hearing, my lord. On Friday it may come, otherwise during
No,
vacation
not
there will
Friday,
be.
January, 9th of January.
It's Friday, my lord,
9th
because,
of January. Don't make unreasonable requests.
my lord,
You're
yes.
fixing a date in January. Why do you want to list it in
My lord, my lord.
Friday? Let it be in January.
May it please your lordship. Insofar as item number 4 is concerned,
Item?
4 is concerned,
Huh.
we had filed the writ petition praying for release of leave encashment, my lord. Now the government has granted a sanction, my lord. Now, the fitness of things, let the matter come up 4 weeks. We'll place that on record and in
Item 4 on the
Item-
request made by the council for the petitioner stands deferred after.
lobster.
Listed after 4 weeks. List again on 21st of January.
Grateful, obliged.
May I please, Lord. I beg to mention for listing of motion, lordship.
Motion matter.
Motion matter.
When was it filed?
Yeah, yesterday lordship, and one is today lordship.
All right, subject to clearance of defects tomorrow.
But the total 6 number of petition are there.
You said one matter.
1 meter is filed on today lordship, and another
Then?
5 are filed yesterday lordship.
Then you're making a mention for how many matters?
6 meters.
Where are your mention memos?
Where it is?
6 matters before this bench. Service matters.
Lordship, the petitions are participated in the revision process of
Oh,
SSCG.
tomorrow.
Obliged.
May I please, your lordship, with the consent of the other side, I beg to mention item number 32 and 38, lordship.
32
and 38, lordship.
and 38.
Lordship.
All right, 32 and 38 stands deferred on the request made by the respondent council. Matter stands deferred to be listed again after 3 weeks.
The interim order development.
Interim order passed earlier will continue, list on 22nd of January or 27th of January.
Much obliged.
May I please, your lordship? I beg to mention for listing of a admission matter, my lord.
Admission in January.
My lord, the difficulty is prolonged unauthorized suspension, my lord. Only dispose of the representation. Similar matter is, my lord, on fixed on 19, my lord. Will not take much time, my lord, kindly.
No. Only motion matters. Only motion matters. If we allow you, we have to allow others also.
No.
Then,
Obliged.
no, you make a mention in January.
Right.
Yes.
May I please, your lordship? I beg to mention item number 1. Kindly pass over it for a day.
Item 1,
Yes,
you want passed over for the day,
yes, my lord.
not day, it will go to January.
So,
Item 1 on the request made on behalf of your name,
on behalf of T. Shaw,
your name.
my name Divya Bosawatan.
M so and so, on behalf of T. Som stand deferred. We listed after 2 weeks
Thank you, my lord.
on 9th of January. Yes,
May I please, your lordship, I beg to mention for listing for motion, your lordship.
tomorrow.
Much obliged.
May I please, lordship, I beg to mention a matter for listing. Lordship, the matter was last listed on 0502.
Motion admission,
Motion.
matter. Tomorrow.
May I please, your lordship, with the consent of the other party, I beg to mention item 11. I may be fixed after
Item
vacation.
11,
Yes, lordship.
on the request made on behalf of
D.
Agriculture.
Sharma. D. Sharma.
D. Sharma for which department?
No, lordship, is for the petitioner.
On behalf of Mr. D. Sharma, matter stands. Then a prayer is made for adjournment, prayer allowed, list again on 9th of January.
Obliged.
May I please, your lordship, I beg to mention item 33 and 34. Lordship, I kindly seek an adjournment. My senior is currently out of station. 33 and 34.
34 stands deferred to be listed again after 2 weeks.
Lordship, interim
List
may-
again on 8th of January.
interim may be continued, lordship. Interim may continue.
Huh?
Interim is there, lordship.
Which matter?
Item 33 and 34. lordship.
Somebody else is making a mention?
She is mentioning.
I
for-
do adjournment.
Both of you are making a mention for
No,
the same matter.
lordship, she is
Interim order passed earlier will continue. It's the date.
obliged. lordship.
Yes.
May I please, lordship? Lordship, I beg to mention an item for listing.
This
It was
week.
yes,
Motion,
yes.
when was it filed?
It was filed on 9 October 25.
Why was it not listed?
It was listed last listed on 29/10.
All right, tomorrow. Tomorrow.
No, after vacation.
After vacation you want. Why are you making a mention now? Come back on 7th. Make a mention after reopening. Yes,
Lord, motion tomorrow, my lord.
tomorrow.
Lordship, I beg to mention a matter for listing. You said the matter was last listed on 20
Admission, motion
motion
matter. When do you want it?
after vacation.
After vacation, you come and make a mention on 5th or 6th. Not now.
Lordship, January 5.
5th of January. All right,
Yes.
5th January.
My lord, one prayer, my lord, in the part 2 list, there is two items, item 112 and 30. During the pendency, my lord, the petitioners have got the relief. And one post of, my lord, join, my lord, Commissioner of Taxes is kept on hold, my lord. There is an interim. So if at all it can be, my lord, closed any day, my lord, on 5th or 6th, my lord, or before, I leave it.
Not
to lord.
today or tomorrow, man.
Yes,
After vacation, man.
can be closed, my lord. They've got the release. 6th, my lord. It will be in the main list, my lord, in that
6th
case.
of
Only-
January, item
Why not, let it be on 7, man.
7 is a miscellaneous.
Seventh of 9, man.
112.
12 and 13.
Or 8, my lord.
Huh?
8, my lord.
Yes.
So what is wrong on 6?
My lord, 6, I will not be here, man.
This for the.
You have to be here.
I'm for the read petitioner, man.
No, you will have,
They are the respondent, man.
you have to be here. The courts are reopening on 5th. So you have to be here on 5th morning.
I leave it to your lordship. Only
1912. All right, item 112 and 13 of part 2 list. Huh?
Yes, sir.
Matter on the joint request made by the council for the parties. Be listed on 8th of
Right.
January.
Mobilize.
8th of January.
Mobilize.
Main list of the reason.
Lordship, I beg to listing for motion, Lordship, tomorrow, Lordship.
Tomorrow.
Obliged, Lordship.
Please, Lordship. Lordship, I beg to mention item number 10 for withdrawal, Lordship.
Item 10 on the submission made by the council for the petitioner. On instruct that the petitioner does not wish to press the petition any further, stands dismissed or withdrawn.
Obvious, Lordship.
Mayor, please, Your Lordship, I beg to mention item number 29.
29.
29. Your Lordship, the leading counsel, Mr. R.P. Foucault, is under the weather. He is suffering from viral fever, Your Lordship.
29 on the request made on the council for the petitioner stands referred to be listed on 28th of January.
Obliged.
This is your lordship. Lordship, I beg to mention item number 25. The order has been complied with, your lordship.
In 25 on the submissions made by the council for the parties. You are for the respondent.
Respondent.
It is submitted that the directions contained in the order dated so and so. Passed in WPC so and so has since been complied with. Stop considering the submissions made. This court does not wish to proceed in either the contempt proceedings. Accordingly, the contempt is stands closed. Notices issued, stand withdrawn. Yes, MS
Escolita on behalf of B. Sharma.
S. Kolita appears on behalf of Mr.
B. Sharma.
B. Sharma. Yes.
Please, Your Lordship.
Yes.
Recruit of 2018, Lordship. Recruitment of 2018, all the poster fill up.
Lordship, petitioner completed, successfully completed all the segments here, Lordship. Lordship, there is judgment of
What is
this.
the grievance? What are you challenging?
Lordship,
What is your grievance?
Lordship, my grievance is that, Lordship, I have successfully completed all the examination, Lordship. And I also scored more marks than the general category. I belong to the OBC category, Lordship.
No, you may have completed according to you, you may be, you may have scored very well. But is this a ground for the court to reopen it and examine how much marks you've got?
Some delay is there.
Why should we reopen this matter? On what grounds have you assailed the illegality? Counsel for the petitioner requests accommodation for the day, matter stands referred to be listed again on 28th of January. Mr. S.S. Roy appears for the NHGC for the respondent.
Have dissolved. My lord, this case relates to compassionate appointment, my lord. Earlier round of litigation, my lord, writ petition, my lord, they did not, my lord. Accordingly, we filed a contempt. Thereafter, my lord, this honorable court was pleased to grant us liberty to challenge the order, my lord. That your lordship will see at page liberty dear page 2. I took your. Oh, I. Page 67 হয় এইটো তো ই হ'ল লিবার্টি দিছে না
We'll issue notice here.
yes man. Only one thing my lord, pendency of the case may not be barred.
Huh?
Only one thing my lord, pendency of the case may not be. Consider my case.
For which Mr.
I took this one.
Tia, it is
I took
okay.
কোন নাই
Yes.
আমি কন্টেম্প করেছিল না
Then
It's a liberty.
respondent
17 number please 70
141 and 4. Who's for health? Who's for health? Anyone for health?
Udo. Lordship can reflect his name, I'll inform.
Mr. B. Gugoi, additional KG, represents respondents numbers 2, 3, and 5. Since the respondents are represented, officers aware, the extra copy is furnished within the period of 1 week from today. What is your prayer here?
Prayer, my lord, we challenge two orders, my lord. Lordship will see page 18. The impine order, there is a 3 impine order, my lord. Those are the
No,
minutes.
then why pendency? What? Why you?
Tendency of the case may not be barred, my lord,
For what?
for consideration my case.
You are challenging it. Where is the scope for consideration? Representation or something is a different issue, but you are challenging these orders.
Yes, lordship.
So there is no scope for consideration.
Lordship. Lordship, fixing matter, my lord, any date of lordship.
Let it be on 2nd of February.
2nd February. 3rd February, my lord.
Third is a Tuesday, let it be, or
That's my lord, my lord.
you want 4th, then we can
Lord,
make it 4th of February. Right. It would do very good, yeah. Mention also. Oh, mention.
Wait, so the petitioners applied for the post of Anganwadi worker lordship. And the national authority rejected the candidature of the petitioner lordship.
Any instructions?
My lord, I have not received instruction, my lord. We have sent it on the 1st of November.
Mr. Emzat Shah of the petitioner, Mr. Here, by the government, pays for the time. For the 3 weeks time granted to the petition, to the state council to complete his instructions, list again on 21st of January. 21st January.
Also, along with the survey report lordship, survey register.
That was the instruction.
Survey register lordship.
Survey register.
Survey register.
That was the
Let us see
instruction.
what
my lord.
instructions comes.
That was the instruction, my lord, thought to me.
Oh.
Obliged.
Item 6.
The respondent had filed an affidavit. So we want to file a objection on that first.
Hard content of arbitration notice return.
Yes, health is the
MS. Then the council represents all the department, all the respondents, therefore notices are read, the extra copies will furnish. The next day. Within 1 week steps, the respondents have filed an affidavit. The council for the petitioner claims liberty to file a rejoinder affidavit. Prayer made is allowed, list is matter on 21st of January. Till the next date fixed, interim order passed, will continue.
I will oblige also.
7.
Where, please, your lordship. Lordship, in this matter, the petitioner was engaged on temporary basis as Anganwadi helper in the year 2012, 24/4/2012, with the assurance on the temporary basis, with the assurance that advertisement will be issued and she will be allowed to participate in the advertisement. But 13 years have passed, your lordship. I have been engaged on that temporary basis only. The representations have been filed, but there has been no response.
It heard council for parties issue notice.
Synopsis.
Yes, yeah, the applicant appears and accepts notice on behalf of all, therefore notices are waived. Extra copies be furnished within a period of 1 week from today. Is after the returnable date. 2nd of February.
Deeply obliged.
My lord, the petitioners were working as sub-inspector statistics, my lord. So field assistant, PAMSAR, etc. But subsequently, they have been promoted as sub-inspector of statistics with effect from 2013. The said promotion was
We need to
given from.
notice here, you are taking
2006.
promotion.
My lord.
Third council for parties, you can notice. Returnable 4 weeks, Mr. Who's for planning? S. Borwa.
Two.
APS for 1 and 2, MSA Botapur for 3, Mr. B. Sharma for 4. Since the respondents are represented, notices are waived, extra copies be furnished in a period of 1 week. List on 2nd of February.
My lord, there is a similar writ petition on the same point pending, my lord. Your lordship would be pleased to page 13, writ petition number 927.
When is it fixed?
927/23.
When is
Page 15, my lord. 927/2023. Along with that, maybe listed. My lord,
We don't know what is that. You make a prayer on the next day.
my lord.
Why, who has filed this petition?
My lord, the similarly situated persons.
So what orders have been passed?
Notice has been issued, that is, route is pending, my lord. Rule is pending.
Then
That is,
you are representing, you are the council in that petition.
no, my lord,
Then
I am not.
let it, let the, will you make, renew this prayer on the returnable date?
My lord.
Here.
Obliged.
May I please, your lordship? But in this case, my lord, earlier one occasion, my lord, instructions was called for, my lord. From the respondent number 1, 2, and 3.
Where is the health department? Health. None represents the health department when the matter is called up on the last occasion. Last date 31/10/2025. The Standing Council Health was permitted to obtain required instructions. Since none represents the health department today, matter stands referred to be listed again on 21st of January, by which date the respondents will obtain the required instructions. List accordingly.
I'm not blessed.
Your lordship, can you pass over the matter for the time being?
No timing today. What is the matter?
Your lordship, I'm not in this case. Give me just 5 minutes. I just inform my senior.
All right, 5 minutes by the watch. Yes. 15.
Lordship, here I pay for some time because the recruitment process is going on, so I could not bring the hard disks, Lordship. Let it be for first week of January, Lordship. Reopening, Lordship.
Yes, lordship, reopening days.
I heard the council for parties, Mr. S.S. Roy, then at CGC renews his prayer for further time. Submits that the matter be listed again immediately after reopening. To enable him to obtain the
7th
instructions. Accordingly, list this matter on 7th of January,
7th, Lordship.
7th,
Lordship.
all right, 7th January.
Obliged.
Mr. So-and-so appears, your name?
NZ Chaudhary.
And the Chaudhary appears for the petitioner. Yes, CGC, prayer for further time is renewed by the learned CGC accordingly. Assistance deferred. We listed again on 7th of January. Enabling the learned CGC to obtain required instruction. List accordingly.
Prevented, my lord.
Lordship has already passed this order, Lordship.
Lordship.
That's
7059
Yes, sir.
2025.
Third council two parties disposed. Again, what is the name of the village?
Village lordship,
Where does one find it?
Bandha Sadhini
Where-
village,
where-
card number 5.
Paragraph?
Paragraph lordship, 3.
Paragraph 3. Paragraph 3 to silo but detail की नहीं है ज़्यादा। Okay. MS Margozoj. MS Chaudhary and Bhattacharjee for the respondents
3 and 4, Lordship. 3, 4, 5, 6.
disposed.
Lordship, delay,
Deeply
my lord. Delay lordship regarding filing of review lordship.
What is the time frame?
Time frame lordship 90 days, it is already over in 9th of December. In this order lordship, already 2 weeks has been extended
So
lordship.
we are giving that same time.
Lordship.
Same.
Lordship.
Deeply obliged, Lordship.
Lordship, my senior is in like in another court. Can you please pass the matter for a timing?
Time being.
Lordship.
Kindly pass over the matter. Lordship, here, Lordship, I have to obtain the instruction. Lordship, let it be on 7 RME record, Lordship.
Huh?
I have to, deformity of chest has been rejected, Lordship.
Third council two parties, the learned CGC is permitted to obtain instructions in the matter. Including the medical records required. This again. On 7th of January.
Lodge.
All the notices are not issued, the extra copies we furnish within the course of the day.
Lodge.
List accordingly.
May it please the Lordship. Lordship, in this matter, the petitioner is rejected on the ground of NCL, Lordship. Lordship, the similar matter is already heard and fixed it on 9 January. Let this matter be.
Petitioner does not submit the OBC creamy layer certificate, Lordship.
Lordship, we have submitted the OBC images. It is annex here, annex
Which
here.
matter is fixed on 9th?
9th.
What is the number of the pen?
Lordship, 7123 of 25, WBC.
7-1,
23 of 25.
you are appearing in this matter, in the other matter.
Yes, in this matter, not other matter, Lordship.
Right, heard counsel for parties, it is submitted that similar writ petition is fixed on
9
9 January,
January.
Lordship.
on 9 January. Accordingly, it is submitted that this writ petition be also listed on 9th of January, along with WPC 7123 of 2025. Ms. S. Purva appears for the,
All respondents.
all the respondents.
Obliged, Lordship.
21.
None appears. That is a party difference. After a while.
22.
My lord, senior counsel Leonard Sodri, my lord, coming. He's a like on court number 2, my lord. 5 minutes, my lord. For the timing, my lord.
For this undertaking,
Yes, my lord.
we have passed an order yesterday.
Yes, my lord. Item number 6, my lord, 7225.
I do not remember.
WPC 7225.
We'll pass similar orders.
My lord. My lord. Same order, my lord.
Usually. Same order is the way. They're insisting on an undertaking.
Yes, my lord.
We had said that this undertaking shall, even if you give it, it shall not prejudice your claims here.
Yes, my lord. Absolutely, ma'am.
Similar, pretty low.
Thank you.
You have the number of the case.
My lord.
You have the number of the case.
Yes, my lord.
What is the number?
WPC 7225/25.
7225 of 25.
Gunamoni Kolita. Yesterday, item number 6, my lord.
Yes, similar order.
Time being item 13.
May I please, your lordship? My lord, as per direction of this honorable court, lordship, I filed the additional affidavit, lordship, showing
When?
that additional affidavit was filed, lordship, on on 9th of December, lordship.
It is not here. There is no indication. It is submitted by the counsel for the petitioners that as directed by the court by the order dated 1/12/2025, an additional affidavit has been filed. Before they will speak. The said affidavit, however, said affidavit stated to have been filed is not connected to the case record. Registry will press out the said affidavit stated to have been filed and list this matter on 7th of January. Mr. D. Nath appeared for the response.
Supplementary list for motion item 41.
Met to the lawsuit. Well, in the light of this order, 22 October 2025, I filed an additional affidavit, my lord. And in the instant matter, my lord, my learned friend, my lord, and relied on case Dilip Talukdar, my lord. My case is also covered Dilip Talukdar, so I am not entitled for the promotion. My lord, this is this question, my lord. In this regard, in detail, my lord, the earlier round of litigation, my lord, I approached before this court. Initially, my lord, though I joined the department in 21, my regularized 2004, and then, my lord, suddenly, my lord, on 15/5/2000 October 10, I am being promoted to the LD assistant, and subsequently in the July, my lord, again cancelled the promotion order. Then I approached before this court, and that honorable appeals, this court order, lordship will find in my additional affidavit.
Notice here.
Yes, lordship, and notice issued, and my lord, one more prayer, my lord.
Honorable 4 weeks, Mr. D. R. Bor appears on behalf of
PWD, my lord.
PW. Who's for the other?
Here, my lord,
R. Bor appears
all PWDs, my lord.
Yeah, my learned friend will take, my lord.
for all. Therefore, notices are waived. Extra copies will furnish.
Yes, my lord, yes, sir.
1 week from today.
Yes, my lord.
List this matter again on February,
February, my lord.
My lord, yes, well, February.
right?
My lord,
For February.
my lord, since my question of regarding entitlement promotion, my lord, I filed a representation before the, in time, there is
Tendency of the writ petition will not be a bar for the authorities to consider and dispose of the representation stated to have been filed by the.
Yes, my lord.
And if any such,
Annexure 7, my lord.
the copy thereof shall be served on the writ petition.
Yes, my lord. If lost.
42.
The copy delivered.
Present.
Not appear. Passed over.
43.
Same order.
Same.
Passed over. Mr. S. Lento from Revenue Department. And Mr. Sutia from the other department.
44.
The petitioner retired from service on 31st of 10/2025 as supervisor, lordship.
of the Howrah project, Lordship. She is claiming, Lordship, for pension under 1969 rules, Lordship. That this is notice may be issued, Lordship.
Yeah, Mr. Sabir. Heard, Mr. Dekala is going to submit. With the, yeah.
2, 4 and 5.
Pending respondents,
And 5.
2, 4,
5.
5. 2, 4 and 5, 6.
6, Lordship, Director of Pension.
I'm
Lordship.
appearing.
Not see, number 8.
8
8,
whether
you
it
are not
is
appearing.
Finance.
Finance not.
The government.
Treasurer in for big over. I
5,
will.
Mr. A. Chakraborty for respondent number
1 and 6 lots.
1 and 6. Mr.
AKB
Bedi
on behalf of Mr. Estimate. Number 7.
for respondent number 7. And who's for 8?
It's a big over. I will inform you.
P3.
And Mr.
My
Nayak
eight.
appears for respondent number 8.
3 is RM Das.
Respondents are represented, notices are waived. Extra copies be furnished within a period of 1 week. 3, Mr.
RM Das. RM Das.
The respondents may complete their instruction and file necessary after.
Outline.
45.
Please, Your Lordship. Lordship, here the petitioner, he retired in the year 2022 as a district transport officer, madam. So just before his retirement, he was arrested in a anti-corruption case. Thereafter, a departmental proceeding was initiated against him, my lord, and the inquiry officer, my lord, Annexure 11, page 55, he was exonerated from all the charges. But till today, they have not dropped the charges, plus I was getting provisional pension. That also suddenly they have stopped from August, man. So my prayer before your lordship is in the timing, my area provisional pension may be released and other matters may be considered. And I have given them.
Please, or you can get instructions.
Lordship, may kindly issue short notice immediately
The
after.
short notice, notice is a notice.
But at
2
least
weeks.
provisional this pension may be.
Lordship, I will get instruction that regarding provisional pension and all. Because this anti-corruption,
Lordship may see the inquiry report. He has been exonerated from all the
I will
charges.
file affidavit.
MS JM Kaur, learned counsel appearing for the petitioner, MS MD Bora appearing for all.
Lordship, 1 to 5, 6 accountant general.
1 to 5, number 6, accountant general, who is there? B Sharma. For accountant general, since the notices, respondents have been, respondents are represented, notices are waived, extra copies be furnished within a period of 1 week. Then to be list accordingly. The respondents will also endeavor to expedite the release of pension of the petitioner
Provisional pension.
and if respondents will also examine and examine whether the petitioner can be released provisional pension till his pensionary papers are finalized. Such a pendency of the writ petition shall not be a bar
Yes.
for the respondents to examine and release the provisional pension if found payable to the petition.
Deeply obliged, Lordship.
After my retirement, I was getting the provisional pension
That
up
we
to
have-
August 2025, my lord. But suddenly from August, they stopped it, my lord. So
Yes,
now
my
that
lord.
I have been exonerated from all the charges, my lord, I should get my regular pension. But before that, whatever
them-
provisional
them-
pension I have been getting, my lord, I should get it. my
Let
lord.
them get the instructions. You have come at the last day, so what can be
Yes.
done? 1 week earlier, we could have directed them to obtain instructions today.
But at least an observation.
The Lordship has
Yeah,
already
yeah.
observed pendency management. Deeply obliged, my lord.
Please, Your Lordship. This is, the petitioners are aggrieved for non-payment of minimum scale of pay. Lordship has already passed similar order in other cases.
Page number?
Lordship, I have also annexed the writ appeal number 45 of 2024, of 2014.
No,
Page
similar,
33.
similar order. Where is it?
Similar order, Lordship.
Where is it? What is the Case number, where is what is the case number?
First page to animal.
Third, learned counsel for parties. Mr. Parsi Musar,
Bisim sir.
PC Musar for the Borough.
Respondent number one, 3, 4, BTC 3, 4 and 5. 3, 4, 5 and
The
6 and 7.
case number is 6168. 6168 of 2025, WPC.
6-1.
68 of 2025.
Similar order. This
Briefly, पास तो होता है एनिमल
My lord, the counsel for the petitioner may have been stuck, my lord. I was informed.
All right, we'll issue notice.
Yes.
That the respondents are represented by Mr.
Respondent, 1, 2,
1, 2,
and 3, my lord.
1, 2, and 3 are represented by Mr. Rai Botaki. Mr. Al Botrijari for respondent number 4. Mr.
BC Musahari.
PC Musari for respondent number 5. The respondents are represented, notices of waived, extra copies be furnished within a period of 1 week from today. The respondents will complete their instructions and file necessary affidavit. Yes, please inform the conflict. Yes.
Lordship, we have requested for VC, Lordship, kindly pass over for time being, Lordship.
48 BC at the end of the list.
49.
Lordship, matters of pass over for the timing.
We can't pass over all matters.
Lordship, my senior is on his way, Your
Huh?
My
You,
senior is on his way, Your Lordship. My senior is on his way, Your Lord.
your name,
Okay, Bhattacharya.
MSK Bhattacharya, Learned Counsel for Children. This writ petition has been filed by the petitioner. Challenging the termination order dated 14/8/2025, issued by the respondent authorities. There are Mr. B. Chakrabarti representing.
Timing, I'm for appearing for respondent number 1 only, Lordship.
PS for respondent number 1. Steps on the other respondents, that is 2, 3, 4, 5, 6, 7. By registered post within 3 working days. Matter be listed after the returnable date.
Otherwise, Lordship, page 56 says that he's in contract service and 1 month notice is enough to terminate. Anyway, Lordship,
Where is the termination order?
Lordship, termination order. Lordship. Annexure 20, Lordship. Page 138.
List after the returnable date, list on 30 January, 30. Please serve extra copies on the petitioner and take steps
Lordship, I'm appearing for 1 only, that.
for respondent 1 and take steps on the other respondents.
Please, Your Lordship, petitioners candidature were rejected due to non-production of the OBC NCL certificate as on 14/10/2024. Lord. The impugn rejection order, Your Lordship, will find from page 109 to 1.
We'll have to issue notice here.
Lordship, there is an interim prayer to keep 4 posts vacant. Because Lordship, the advertisement stipulated that a verification has to be conducted once the candidate produces the certificate of OBC. Here in my case, Lordship, the rejection was done on 26/11. On 25/11, the district commissioner intimated the recruitment board that the petitioners belong to the OBC NCL category for the financial year 2024 and 25. And 6,
So after selection on the date fixed, you have to produce the certificate. Why was it not?
no, in respect of candidates who belong to the West Karbi Anglong and Karbi Anglong district, they could not obtain the NCL certificate because of the issue that in February 2024, the Karbi Anglong Autonomous Council has issued an notice directing for eviction of 11,000 acres of land. The petitioners, they resides in that particular area. Therefore, their applications for issuance of OBC.
Then we'll have to hear the matter. Third council for parties issue notice MSS. Barwa represents, CDC represents respondents 1, 2, 3, 4, 5, 6, 7. And MS Tolita appears for respondent 8 and 9. The grievance of the petitioner is the rejection of his candidature for non-production of OBC
NCL certificate as on 14/10/2024.
14/10/2024. The petitioner had appeared for the post for recruitment to the post of constable in CAPF. What to do with the interim order?
And Lordship, it is clearly mentioned in the advertisement that the crucial date of the subduction of.
We are asking you, supposing you proceed with the interim, with the appointment, then we'll have to make it subject to the outcome of the writ petition.
Yes, Lordship, but whether
May I take your Lordship to page number
vacancy
38?
position is.
Because clause number 6.1 of the advertisement says that once a candidate produces a certificate in respect of his caste status, if he fails to produce, his candidature will be applicable, accepted in the category in which he applies, 6.1, Lordship. And
General.
6.5 stipulated a specific date, as on 14/10, he has to produce here. Now, 6.8 says, once he failed to produce it, the relevant caste status certificate, a verification has to be done by the appointing authority to the caste issuing authority. And now, the difficulty for the respondents, Lordship, may I take to.
All right, notice on the interim prayer, returnable on 7th of January.
9 January, some similar matters are fixed, Lord.
Because Lordship, they fixed the date on 14/10. Now on 5/11 to 7/11, they say that a windows is open for correction of the application form.
No,
Now,
that's okay, but let us let them obtain the instructions. Before that, we can't give you anything.
Lordship,
9/11 similar matters are pending.
9 January.
9 January.
7123, Lordship.
Seven
7,
on 9,
Lordship, 7123.
9, released on 9 of January.
51, Lordship, his candidature was rejected in the review medical examination because of hypertension. Here in the page 49 is the rejection. Your Lordship is well aware that in case of hypertension, 7E of the guideline has to be followed, wherein they has to mention that whether the hypertension is because of the transient or not. Here, nothing has been mentioned. And in fact, what is shocking to see, Lordship, on 22/11/2025, the petitioner was taken to Narayana Hospital by the respondents. And if your Lordship peruses page number 49, on 19/11, they rejected his candidature. Therefore, it is a clear case that they did not consider the report of the civil doctor, which they have referred.
When was he referred to Narayana? Where, the civil hospital? Page number?
Lordship, that they do not provide to us.
No, according to you, on which date?
On 2011-2025. And the rejection was on,
It heard counsel for party issue notice. 4 weeks. Hypertension, have we disposed of any matter?
yes, Lordship.
Yes, Lordship. But
And
here, the
holding
record and report of Narayana Hospital is also required, Lordship. What is the,
What order was passed?
as per guideline, he have to be admitted in the
Para 5 to
hospital,
10
Lordship.
are the relevant paragraphs.
Into this,
Moving it on, I'm ready to run.
6999, no?
6099. On 15/11, the respondents referred the petitioner to Apollo Hospital first, where they conducted the DME. His blood test was done, urine test was done. He was found fit in his blood test and urinal test, everything were normal. During the RME, nothing was conducted, and they just measured the blood pressure of the petitioner.
You get instructions on 7th.
Yes.
If you have the medical report, we'll dispose it off.
Not sure.
Similar lines, but council for parties, matter will be set on 7th January, enabling the learned CGC to complete the instructions in the way. Although notices have not been issued, the extra copies be furnished within 2 working days to the respondents. It's from 7th January.
All right.
Yes. Nine.
May it please, Lordship. Lordship, petitioner was appointed, Lordship, as LD assistant, Lordship, in cooperative session, Lordship. And Lordship informs, in case of seniority list, Lordship, is private respondent has been superseded, Lordship.
We have to issue notice here. What is? Notice.
Not, Lordship.
Right, council for parties issue notice. We would have done it on the matter was called up last. Your colleague said
Lordship.
there were some prayers to be
Yes.
made. We issue notice returnable after 4 weeks. Mr. Bordoloy appears on behalf of
Respondent number 1, 2, and 3, Your Lordship.
1, 2, and 3. And Mr. T.C. Sutia for respondent number 4. Therefore, notice since the council represents respondent 1, 2, 3, 4, notices are waived, extra copies are to be furnished within 2 working days. Steps on respondent number 5 and 6 by registered post within 1 week. This matter again after the returnable date on 2nd of February.
April.
21. Timing item 21.
Please, Your Lordship. Lordship, I have filed the RTI application, but the authority has provided me the information that are not correct information, Your Lordship. And after that, Your Lordship, I have filed a first appeal before the district and session judge Lakhimpur. Your
What
Lordship,
information
but
was,
they have-
where is your application? RTI? Where is the RTI application?
Lordship, it is on page number 2021.
20?
20.
20.
20, Your Lordship. Lordship,
Then what was the reply?
Your Lordship, that not provided me the correct information, Lordship. After that, Your Lordship, I have filed the appeal, the first appeal before the district and session judge, Your Lordship, but this is the same, Your Lordship.
It is not available in the website.
Yes, your lordship. Lordship, thereafter I have filed a second appeal before the Assam Information Commission, your lordship, but they have not conducted the hearing, your lordship. Lordship, at this stage, notice may be issued, your lordship.
No, why should we issue notice like that? Where is the standing council, high court?
May I please, your lordship? May I please, your lordship? Lordship, I am appearing on behalf of D. Burman, your lordship. I am appearing on behalf of D. Burman, your lordship. He is out of town, your lordship.
So what do you want?
Lordship, no, I am informing my lordship.
Where is the high court standing council? Asant here. Somewhere. We'll have it tomorrow.
Lordship.
Request the high court standing council be available in the matter. This tomorrow,
Highly obliged.
showing the name of high court standing council, Guwahati High Court.
Timing item 48.
Also, in this matter, we are challenging the selection process conducted by an examination for examination conducted by an employer. Lordship, the annexure one, the advertisement.
What is the advertisement for? Appointment of what?
Appointment of lordship various posts.
You are applying for what post?
Number 4 lordship, junior executive officer.
Page number?
Page number
Page
22.
number?
Yep.
Advertisement is at page number?
22 lordship.
22.
Lordship, I kindly see the junior executive officer, total number of post lordship 17.
You are reserve category candidate?
No lordship,
Unreserved.
unreserved
So
category.
you have access, you are available, 13 posts are available for you.
Lordship.
Yes.
Okay. There, lordship, the final list at lordship annexure 5. So page 29 lordship. Lordship, here lordship, respondent authorities has announced only for 7 candidates. But the question is how it has reduced to 13 to 7 number of posts that has not been explained. There's no final list, no merit list, no marks, no advertisement with effect to reduction of the number of posts. Lordship. Lordship, I have given the written test also. Thereafter, I was called for.
Yes, who's for the?
I appear for respondent number 1, 2, and 3, madam.
1, 2, and 3.
Madam.
Can you get instructions as to why?
Yes, madam, I have to.
Why the 13 posts were showed and results are declared for how many?
Yes, madam, total, my lord, lordship kindly see 17 posts were advertised. Out of that, my lord, there are 3 categories, 1 HR, 1 finance, and 1 technical. In the advertisement is mentioned, my lord. On HR category, 3 were appointed, and petitioner is for HR category. The advertisement, 3 categories are mentioned, my lord.
Where?
My lord, your lordship will find page 24.
24.
My lord, junior executive officer, computer science, finance, and HR. So 17 posts were advertised and 7 have been appointed.
It is an advertisement of 2021.
Person has applied for what post?
She has applied for HR. From that, my lord, that much instruction I have that three persons have been appointed.
But you are showing unreserved 13 posts.
Yes, my lord. Unreserved as a whole, this is reserved position is different thing, but the three categories of post.
No, but how many posts have you filled up?
3. Altogether 7 for HR, what she is concerned with, my lord. Only 3 have been appointed.
No, come to page number 29. So for junior executive officer,
Yes, my lord.
in all categories,
My lord.
is 6+1.
Yes, my lord. Yes.
So
So,
there
my
are,
lord,
there
all
are
these
still
6
7 posts unreserved, which are to be filled up for junior executive.
Initially, advertisement was for that 17 post, my lord, in 2021. Maybe, my lord, at this stage, my lord, this is a settled proposition of law that all the posts are not necessarily to be filled up, my lord. First thing. Second thing, just appear in the interview, that doesn't mean that she has any wastage right.
No, there, we are only asking you, have you filled up or not filled up?
This post I have filled up, my lord.
That we can see, but what about the other posts?
Other posts we have not filled up, my lord.
So the question is why?
And that is the thing, my lord, should come from record, my lord.
Right.
For what reason they have not filled up, my lord?
So you get your instruction.
My lord, that's it.
And if they are not filled up, you don't fill up one post till the next day.
Yes, the rest of the thing. Yeah. My lord, I get the instruction, my lord. Should we fix a date, my lord?
Third, council for parties to notice returnable 4 weeks. Mr. B. Shalamosi represents respondents 1, 2, and 3.
1, 2, 3, my lord.
At this stage, we are not issuing notice to the others. Let us see what instruction comes up.
There's an interim period.
The petitioner is agreed, but in terms of the advertisement dated 24/09/2021, by which advertisement was issued for four categories of posts.
3 categories, my lord.
Huh?
3 categories.
4.
Total 4, my lord. In junior executive, there are 3 categories.
That does not show in the advertisement list, Lordship.
4 categories of posts, to which the writ petitioner had applied only for junior executive officer. In respect of junior executive officer, there were 13 posts shown to be advertised for filling up by way of selection. The petitioner belongs to unreserved category. It is the submission that pursuant to the results being declared by notification dated 9th of December 25, only 7 posts have been shown to be filled up under the unreserved category in respect of junior executive officer. It is submitted that there are 7 posts available for which results have not been declared. And according to the petitioner, she fared well in her examination. However, in the absence of any marks being declared by the department concerned, she is unable to fared well. However, the mark sheet, etc., has not been declared by the department. But under such circumstances, petitioner is before this court. The respondents will complete their instructions and file necessary affidavit in the meantime. If the remaining 7 posts are not filled up, then till the next date fixed, one post from those 7 vacant posts shall not be filled up. placed again on 4th of February.
Lordship, interim, they have maybe considered.
We have given you an interim prayer. Yes.
Deeply obliged.
There is no order, second, 23 and 24.
What is this matter?
In this case, the petitioners equal sheet were initially engaged as master workers, my lord. They were subsequently regularized. But their salaries were not paid, but as on regular basis, my lord. Regular scale of pay was not paid. They approached this honorable court. This honorable court, my lord, while dealing with the matter, my lord, directed personal appearance of the director of transport, IWT. He appeared before the honorable court. He submitted before the court that my lord, some typographical errors were kept in the names of the petitioners, for which my lord, approval came wrongly from the finance department, and that is under process for rectification of the finance department. On that basis, my lord, this honorable court directed the finance department to grant the my lord, approval against the rectified names. And accordingly, the petitioners are working in the said capacity. That order of regularization is still there, my lord, that has not been recalled by the authority. Against the order passed by the honorable court,
yes,
they preferred a review petition. Review petition was disposed of along with the batch of writ petitions. Those cases in the writ petitions were, my lord, related to those master workers whose services was not regularized pursuant to the cabinet decision dated 22/7/2005. But the petitioners herein, my lord, their services have been regularized pursuant to that cabinet decision. So
that order was not recalled.
That order was not recalled.
That
No,
order was
Lordship,
not.
that is not correct, Lordship. Lordship, my brief has not yet reached, Lordship. I'm taking her brief, Lordship. Lordship, one affidavit is there by the Director, Inland Water, Lordship. In the miss case filed in the earlier writ petition, Lordship, that is 4759/2007. Herein, Lordship, the Director has mentioned that Finance Department by letter dated so and so 2/11/2006 has cancelled the regulation order.
Where is that order? Show us that order.
That order mention is there, Lordship. Now he is raising this question for the first time, Lordship. In fact, Lordship, in
That
the,
was the obvious question to be raised.
no, if you take the Lordship, if Lordship takes the repetition,
Even assuming we accept your contention that the review came to be disposed of,
yes,
that review was against the order of a coordinate bench,
yes,
against which appeals were also filed. Ultimately, that
judgment passed by the
judgment
coordinate
was
bench
passed,
was
Set
I mean,
aside.
set aside.
set aside.
So in the review, Lordship, before the learned single judge, my review was dismissed.
All right, dismissed.
And
or
before
disposed
the
of, whatever.
before the division bench to us, it was reversed. So my review has been allowed, Lordship.
No, if it is allowed, then the writ petition ought to have been recalled. Order ought to have been
No,
recalled.
Lordship,
matters ought to have been-
it was considered in that way, Lordship.
No,
What
can't
can
be
I do,
considered
Lordship?
that way. It's a-
And in
it's
the
a-
entire proceeding, Lordship,
it's a
he was a
judicial
party.
order.
In the end,
If your review is allowed, if your review is allowed, then the order against which you had filed a review,
but
that
Lordship,
order goes
Lordship-
and the writ petition will have to be listed for
Lordship,
hearing.
in many cases, Lordship, I have seen in review petitions also, review was not sent back to the learned judge, Lordship, and it was decided there itself.
Decided,
And it was by the division bench, Lordship.
no. You cannot have an omnibus
No, I'm
principle
not
to say that
submitting
this is
that,
how it
Lordship.
works.
But what I'm submitting
What
at
we are
this stage,
saying is not only my experience, is also what the
Lordship.
rule book says.
Lordship. But what I am submitting, Lordship, in the present writ petition, Lordship, contempt is a different issue, review is a different issue. In this case, his grievance is entirely different. His grievance is Subsequently, in the first stage, Lordship, his name was never forwarded by the concerned department to the finance department for consideration of regularization.
We are not on that.
No,
We are
I'm
that-
coming, I'm
that
coming.
There is an order of the court, order of the department where they have been regularized.
No, that order is not before your Lordship. What is pending before your Lordship is 2194/2013. Now, Lordship will see what is the prayer there. Here the prayer is that OM of 2012 should not.
Already I have stated that I'm not pressing the prayer.
No, he is claiming the benefit on the basis of that notification only. Lordship, it comes to the first prayer.
Where
Lordship.
is that notification?
That notification,
OM?
Lordship, that notification was initially set aside by the learned single judge, same order. And subsequently, as the single judge's order was reversed, Lordship, this came into effect. But your Lordship, this decision has already been done. This is a covered case in that sense, Lordship. Lordship, here the prayer was quashing or setting aside the impugned office memorandum dated 16 June 2012. Lordship, in this notification, Lordship, a decision was taken that henceforth there shall be no regularization of master and works as employee, and there shall be no creation of supernumerary posts. As his case was pending before the finance department for consideration of his regularization, Lordship, that was this notification was
That's all
sent.
right. Now, let us assume that he does not press prayer A.
Lordship.
Prayer B and C, if it is to be considered, I mean, if it is to be considered, then what you say that.
Lordship, then
it has
Lordship
been
will,
cancelled.
then Lordship will come to B.
B.
Prayer B. A writ of mandamus should not be issued directing the Commissioner and Secretary to the Government of Assam Finance Department to approve the proposal of the inland water transport. It was subsequently proposed, Lordship. In the first stage, their names were not there. Their names were not proposed by the concerned department.
For correction.
Subsequently, Lordship, subsequently, Lordship, in the 2006, their names were forwarded.
No. At the time when the order at page number 59 was passed,
Lordship.
what was the?
Lordship, that why we filed a review petition, because that decision was made, Lordship, on the basis of submission made by the Director, Inland Water Transport. Finance Department view were not there. And only for that reason, Lordship, the Finance Department filed a review petition.
We are not on that. We are asking you, whatever view has been made by the director recorded, what was the position then?
Director said, initially, Lordship, number of posts approved by the cabinet, I think it was around 1,472 or 73, Lord, 72. Director changed that list and included name of the petitioner, including the name of the petitioners, and regularized their services. That is the, pleaded stand of the Finance Department. And subsequently, when it came to the notice of the Treasury Officer, he stopped their salary. The entire matter was inquired. Transport Department was instructed by the Finance Department to make an inquiry. And ultimately, Finance Department rejected that list, Lordship. And that list is of around 57 regularized master roll workers, including the petitioner. So it was cancelled. Subsequently, Lordship, in 2006, Finance Department issued another notification directing all the departments to submit the names whose names were left out, Lordship, in the first phase. Accordingly, the name of these petitioners were forwarded to the Finance Department. First time, their names were never forwarded. So there is no question of typing error or whatever.
I don't know what is recorded here in the judicial order has to be.
That is why that order was reviewed. The review
Sought to be reviewed, but it was never reviewed.
The review petition was disposed of.
Review petition was disposed of means this order has to be set aside, reviewed. This order has got nothing to do with the penultimate directions issued by the division bench in Upenda.
No, it depends upon the interpretation, Lordship. Learned Finger just prepared
this.
Learned
This
Finger just, Lordship.
This order is with regard to why their salaries were not paid. This order came to be delivered on the statements recorded by the director before the court that their names were wrongly spelled.
Yes.
And now we have made the corrections and it will be done. That was
No, that is not. It was the stand of the director that their names were subsequently corrected. And accordingly, Finance Department was directed to give concurrence. But it was not the stand, actually. It was not the stand of the finance department, and finance department stance was never taken into account while passing that order.
That's right, but
Yes.
therefore you filed a review.
Yes, Lord.
So therefore, the consequential thing ought to have been that this order ought to have been recalled. Or the court would have said, no, there is nothing wrong, there is no error in this order.
Lordship, in the earlier earlier in the entire pleadings, Lordship, my
Now-
friend appeared.
Now, therefore, what remains now is that according to the writ petitioner, he is relying on this order to claim his salary with effect from the date which he says they were regularized.
Not from that order, Lordship. If Lordship comes to the writ petition,
Ah.
present writ petition that is pending before your Lordship. He is not saying, he is first pair, set aside the notification of 2012. Second pair, give approval to the names pending before the finance department. When the names were forwarded in 2006, in terms of the second notification issued by the finance department, not in terms of the court's order or in terms of the first phase.
When was it sent for?
Second time, yes, that's it. I'm
When
coming
was
to
it
that.
sent for regularization? They were regularized in 2005.
Yes, the concerned director regularized, but although their names were not approved by the cabinet or the department,
So
finance
that is-
department.
That is what he is claiming.
Lordship, their names were forwarded on 29 November 2006. That is after the first phase.
Well, so B and C has to be read together. Prayer B and C will have to be read together. He's claiming it from 21/10/2005. So where is that order 21/10/2005?
That is the first regularization.
Regulation order is, my lord, at page 41.
41. So he's claiming the regular pay from this order. Now your records say that this order has been cancelled.
No, but if Lordship comes to the third pair, Lordship, in my understanding, Lordship, this is the consequence of pair B.
Oh.
If approval is given in terms of pair B, Lordship, then he's claiming regular pay, but he is claiming from 2005.
Actually, the finance department will either give approval or not give approval.
Lordship, in the
Assuming-
earlier
No,
order
what is
also,
what will
earlier
happen
order,
if Approval is not given.
Lordship, in the earlier order also, although a direction was issued to the finance department to give concurrence, no direction as such was there that pay them from 2005. This direction was not
We are
there.
asking you that page number 41 order as per the director is the date of regularization.
Yes.
He, according to him, he has put it up before the finance department. Now, let us say finance does not accept this order. What is the consequence to be followed? What is the consequence that will follow?
I mean, the subsequent proposal, Lordship.
No, not subsequent proposal. What is the consequence which will follow if the finance does not accept or approve this particular order
Yes.
with effect from this date? What happens? They
No,
will not
Lordship,
get their regular salary.
Lordship will consider this prayer is not, if Lordship.
Forget the prayer. I'm asking you on the facts.
Yes.
What is the consequence that will follow?
He will
not
remain
get
a
the salary.
master of Lordship.
He will not get the salary.
Yes.
Regular salary.
Yes.
So therefore, for the department to send it up again, this order will have to be recalled or cancelled by the department or replaced before the finance department by meeting the objections.
No, order means what is before us, only the order passed by the learned single judge, the first order of 2007.
We are referring to page 41 of the writ petition.
Yes, Lordship. No, it was cancelled.
Now,
It
that
was-
is what we want to know. Where
It
is
was
the
cancelled,
cancellation?
Lordship. On 3 occasions, we have mentioned, Lordship. Lordship, in the review petitions,
Do you have a copy of that order cancelling this?
statement is there at this point of time. I am only having the statements. The
You have to show us from the
one
record.
made by the director
No,
IWP.
no, you have to show us from the record that this, either you say this order is not existent, this is not there in the record. Whatever
So far as statement, I have not yet inquired for the order, Lordship, but what I found, Lordship, in the affidavits, Lordship, one,
existence.
you are-
Accordingly, regularization of their services were cancelled by finance department.
Are you disputing their claim that they are not regularized at all?
So far as government is concerned, no, not at all.
Never.
It was by the director only.
No. Are they regularized now or not? Are they getting a regular pay?
No,
They are not getting it.
not getting.
So subsequently, when you send it up, subsequently,
They forwarded that.
who forwarded?
Transport department. Subsequently, Lordship, another, in the first page, Lordship, 2005. In 2006, Finance Department again issued instruction to all the department to forward names, whose names were left out in the first page. Accordingly, in the second page, their names were forwarded.
Right, then what?
Not in the first page.
Then what happened after that?
Lordship, thereafter, Lordship, I mean, that Umadevi came, Jitan Kalita came, one order passed by the division bench, Lordship, Tarini Deka. And Lordship, thereafter, in the second page, nobody's services were regularized. Then
No one is regularized.
No.
So what is their status now?
they are working as master, and in terms of Upendas, they are getting minimum pay scale, Lordship.
Yes.
And one order, Lordship, I am placing, Lordship. This is order dated 29/4/2013, passed in the present case, Lordship. Court directed list along with review petition number 57/2009 on 17/5/2013. And my friend appeared in the judgment passed by the learned single judge, that is Upenda's judgment, Lordship. Therein also my friend's name is there. He was appearing. So
appearance doesn't have, because he's the beneficiary of that order. He's the beneficiary of that order. So and everything rests on that order of cancellation. You produce that order of cancellation, his writ petition falls through. You're making a statement on instructions, isn't it?
that statement is here in the affidavit.
That statement is on the basis of what? Instructions given by your officers.
Yes.
That
Affidavit filed
instruction
by them.
has to flow from the records. So show us that order.
That may be one aspect of looking at the issue, Lordship. But my case will be, Lordship. In this case, he is praying for regularization only in terms of the second instruction of that in the second page.
No,
Not for the first page, Lordship.
He's praying for.
And that is why he is praying for setting aside of the notification of 2012.
You come to prayer C.
Prayer C, Lordship, is the consequence of prayer B. Prayer B. In terms of first regularization, Lordship, he received regular pay for some time, Lordship. It was subsequently, stopped by the treasury officer. So, Lordship, may kindly see the date, 21/10/2005.
That's right.
So, on 21/10/2005, he was getting a regular salary, Lordship. There is no question of allowing now, Lordship. So, what he is praying, Lordship, is a continuation.
Continuation with effect from 21/10.
21/10, that is the first regularization order. In terms of the first regularization order, he received regular salary.
Right.
Subsequently, it was stopped by the treasury officer. So there is no question of paying regular salary from 21/10/2005. What he is paying only continuation from 2005.
He says it is with effect from, so which means 21/10.
So that is his prayer, Lordship.
21/10, if you have paid and if you have stopped it in 21.
Subsequently, Lordship, before 2006, yes.
Then from the date you have stopped it, you give him a regular pay in terms of this order. That is his prayer.
For that, Lordship, second B, that approval remains, Lordship.
That approval or
No,
no approval?
Lordship will read the prayers.
That approval in terms of the statement of an officer of the state has been recorded in a judicial order.
My understanding is that,
according to you, you had sought for correction, but there is no specific order recalling that order.
Lordship, my
The
understanding,
only way to correct it is to produce that order on the basis of which you have made a statement in your reading that it has been cancelled.
So far as, definitely, Lordship, if Lordship directs, I have to place that order.
No, you have
So
to
far as
place-
present
otherwise-
petition is concerned, Lordship will read the prayers conjointly. Why he is aggrieved against that order of 2000, notification of 2012? Because if it is given effect, Lordship, his proposal will not be given approval by the finance department. That is why he is
aggrieved against the OM of 2012. Second prayer, Lordship, on
Second prayer has to be read now in terms of the judicial order.
no, Lordship pleading so far as I went through the writ petition, Lordship. What I found, Lordship, he only mentioned that earlier also one such direction was passed. But this is not his grievance. By filing this writ petition, he never prayed for implementation of the order passed earlier.
Oh, don't go by
Lordship,
the.
what he is
don't-
praying, Lordship, and that is why, Lordship, he
what
has
he's
filed a
praying-
present contempt
His
case.
prayer is very clear. Direction to the finance department to approve the proposals.
Yes, ma'am.
Approve the proposal.
Lordship,
of
in terms
correction
of the
anomalies. That is the prayer B.
Lordship.
That is the prayer B.
Prayer B is, so prayer, if the notification of 2012 remains, then his prayer will be considered. That is why the grievance against 2012 OM. If 2012 is not there, his proposal will not be given approval. That is his understanding, my understanding, Lordship. And that is the pleading in the writ petition.
Prayer A is a misconceived prayer, my lord, because my lord, this prayer is not required for those. persons
Now he
who
may
have been-
try,
have
Lord.
already been
Now-
regularized.
Now he may try. Now he may try.
Now this 2012 notification has been set aside already.
Initially set aside, but subsequently that judgment was reversed.
Then
So this effect remained. Subsequently, Lordship, another notification came in 2013, and that is in terms of paragraph 53 of Uma Devi. But Lordship, at this stage, Lordship, he is praying for approval. And approval will be given only if the notification of 2012 remains. So that is why he is praying for setting aside of 2012.
The approval of the anomalies in terms of the earlier order, my lord.
Lordship, in the first stage, there were no anomalies because their names were never forwarded in the first place.
Still finding.
this policy decision, again, assuming it is effective, will be from 2012.
Yes.
2012.
But their consideration of their names were still pending, Lordship. That is the reason.
Their names were pending, but
yes,
the orders were.
I mean, till 2000, till filing of the writ petition, their names were not considered. That is why they thought 2012 will get hurdle towards considering.
He
their
does
names.
not want to press now.
No, if it is not pressed, second prayer will have no meaning, Lordship. That is my understanding, Lordship. Lordship, ultimately, what this is,
No,
Lordship.
your understanding has to be in terms of the law, because this notification will be with effect from 2012.
No, I'm again reading, Lordship, prayer B. Prayer B is not, he is not saying that give approval to my name in terms of the order passed earlier. It's a simple prayer, Lordship.
Approve.
B. Directing the Commissioner and Secretary to the Government of Assam Finance Department to approve the proposal of the inland water. Proposal was sent when, Lordship? In 2006.
Well, prior to 2012.
Prior to 2012. Finance Department approved the proposal of the Inland Water Transport Department for correction of the anomalies towards regularization of their services for the purpose of release of their monthly salary. Proposals were submitted only in the year 2006
For what? For correction of anomalies?
for regularization.
No, for
Lordship will see
correction.
Lordship will see how it was forwarded.
Where is the proposal?
Yes, Lordship, I'm sorry.
So instead of going through all this, you produce that order by which it was cancelled.
Yes.
You have made a statement in your affidavit that it was
From the
cancelled.
affidavit, yes, Lord.
So you
From the
produce that order.
affidavit as well as in the affidavit filed by the director.
You produce that order or some reference from the records so that we can record it and close the matter.
That is one. But their names were forwarded, Lordship, on 28th November 2006, and the reference was 31st of October 2006. That is the subsequent instruction issued by the Finance Department.
We don't know, but we go by the judicial orders here. This order has not been referred to, reversed, recalled. How can you read this order to be disposed of in terms of either of the single bench or the division bench order? You can't do.
Lordship, we filed a review petition, Lordship.
You filed, you did not.
Accordingly,
raise.
it was disposed of.
You did not.
And the
raise it.
learned single judge preferred not to remand it to the learned single judge earlier, Lordship.
That is the
At
end
that
of it.
point of time, my Lord Gogoi was not there
So
also.
therefore, that particular order remained. A judicial order can only be corrected by using the judicial process. I pass an order.
Yes, that is there,
I pass
Lordship.
an order, I can correct it, or a higher bench can correct it. And if once I debit office, that order will have to
Lordship,
be
if
corrected
it was,
by way of
it was,
judicial
if it
procedure.
was passed in that manner only, Lordship, what I can do, if it was not passed the way your Lordship is, I mean.
So the way I want is not my personal wish. This is what the rule says. This is what the spirit of CPC says. This is what the High Court rules say. Once you file a review,
My problem is
either
that,
you reject the petition.
my problem is that once the review petition has been disposed of, if Lordship comes to this phase, Lordship, it is.
It may mean two things.
It is clearly stated, case disposed 28th December
Correct.
2013.
Disposal may mean that you have accepted the views of the division bench and not pressed the review petition. So instead of dismissing it, it will be disposed of. As good as saying not pressed. That is their
Ultimately,
interpretation.
ultimately, it's the same order, Lordship. That is what my problem is, Lordship. Now I cannot.
Disposal of an order cannot by implication interfere with an order. There has to be a specific order.
If Lordship comes to the earlier order, Lordship, I mean, the order passed by my Lord Justice U.V.A. Lordship, there the ultimate sentence was the writ petitions are the petitions are disposed of in the manner directed above. So that was the ultimate line, Lordship.
There also the review was disposed of.
Review was disposed. And accordingly, Lordship, in the case status, it is mentioned as case disposed.
Disposed.
We went before the division bench. Lordship, in that case, Lordship, before the my Lord Justice U.V.A., he was appealing.
There is a fallacy here. You filed a review. It was listed before a single judge, single coordinate bench, along with other writ petitions.
Along with these petitions also, Lordship.
All right, whatever petitions,
Yes.
writ petitions.
But
So you have-
subsequently, it was segregated. I don't know how, Lordship.
What I understand from your submission is there were writ petitions and there was a review petition. Both were listed before a single judge. Writ petitions were disposed of. Review petitions were also disposed of. Now, if you are aggrieved by the review petition, then you can't file a review petition again before the appellate court. You have to file a writ appeal.
We filed an appeal. In the appeal, Lordship, if Lordship comes to open the judgment, the review petition is mentioned.
How can the review petition again be listed before a division bench?
Not
If
the
it is
review
disposed
petition,
of
Lordship,
by single
we file appeal against the judgment passed by the
therefore-
learned single judge
Therefore,
in the entire
therefore
list
the
of cases.
lawyers or the registry somehow missed out this aspect that the review petition was already disposed of by a single bench. How can you now file an appeal against against an order disposing a review petition and have the same nomenclature as a review petition filed before a division bench? You can't do that. It has to be in the form of an appeal.
I mean, from the petitioner's side also, that argument were never raised.
They are not concerned. because the
Ultimately,
review is not preferred
ultimately,
by
division
them.
bench
It is
disposed
by
of.
the state. It is for you to say before the court. You file a writ petition, it gets disposed of. You go before a division bench, it has to be in the form of an appeal. Unless the matter is placed before the larger bench for specific orders or challenge to the various of act or rules. Similar, when you file a review petition, it is dismissed, disposed of, whatever. If you are agree, it has to go in the form of an appeal only.
That is what I'm submitting, Lordship. Then in that situation, Lordship,
Therefore, the review petition could not have been listed before the division bench for it to be disposed of.
Lordship, in that situation, Lordship, if that is the view, Lordship, even if I place the cancellation order, I will not get any
You
relief.
don't know. You place the cancellation order. You place the cancellation order.
And I understand what your Lordship
That
is saying.
interpretation has to be, even if, because see, single judge did not refer all the writ petitions and the review petition to be placed before division bench. That is not the order. Order is writ petitions disposed of. Single bench. And that also, although no specific order is passed, review petition is also shown to be disposed of.
Lordship.
Now the aggrieved parties go in appeal before the appellate court. The aggrieved party in the review petition, if they want to go before the appellate court, it has to be in the form of an appeal.
Yes, it was an appeal, Lord.
Then how the review petition is listed?
All the petitions were listed, Lord.
That is some defect in the system that it got listed. But you cannot have the review petition dismissed in the single bench and again place it before a division bench to have it dismissed again. Can it be done?
Otherwise also, Lordship, against that order, Lordship, order of 2007, we filed a contempt case now.
All these are all right. What we are
contempt
asking
is
you
also
to
not
do is that if you
maintainable.
have already cancelled this order,
Yes.
you place it,
Lordship, I
because then it will be left to them to challenge that order or do whatever else they want.
I have not yet talked to the department, Lordship, what is it about that later, Lordship. But
Because
as it is
you
mentioned here,
you
as it is,
mentioned it in
Yes.
your affidavit.
it should be there, Lord.
Has to be there.
It should be there, yes.
So you place that order for cancellation.
Lordship, I will try.
Otherwise, the judicial order remains.
In that case, Lordship, in that situation also, the order passed by the learned single judge will, earlier, Lordship, will remain, Lordship. If review is not having any consequence, Lordship. If filing of my review petition, its disposal before the learned single judge, its reversal before the learned division bench.
No, you see, the disposal has no consequence unless there is an order recalling that order of which you are seeking a review.
Lordship.
That order has to be recalled, therefore you are filing a review. If it is recalled, then the writ petition has to be posted for hearing. Can a review petition be disposed of without recalling that order?
That is the law, Lordship. That
What
is
is-
the law. But
Ah.
I have seen many situations, Lordship, where the reviewing or court, Lordship, has already disposed of the entire matter.
May have disposed of by modifying that order, it is possible. If the single judge would have said that, all right, we are not recalling it, but this order, we are disposing the review petition with this particular order modifying it. There is no modification here.
Yes, I go down to what your Lordship is saying, but
There are there are
only,
two different directions. One is saying something else, the other bench is saying something else.
yes. No,
And
my only understanding is that when the learned single judge and my Lord Justice UBA passed that order and ultimate line in the manner all the petitions are disposed of. I thought the earlier order passed by my Lord Justice R. Gogoi Lordship has been modified in that manner.
all right, if it is modified, then what was the need for going for an appeal?
It was not in my favor. It was not in my favor.
How?
Lordship, because that order was not in my
Against
favor.
which you went in appeal.
That is why we went for it.
What was the direction there?
In the writ petition, writ appeal.
Writ petition?
Lordship, a direction was there for frame a policy. Consider the cases of the petitioner.
But in their case, there was no question of framing a policy. They're relying on an order of regularization. According to them.
No, in that situation also, our case was, in the review petition, our case was that as their names were never forwarded by the department, Lordship, as their names were never approved by the cabinet, So there is no question of regularizing their service. In fact, the authority lordship, suspended persons lordship, initiated departmental proceeding against the erring officials lordship.
This writ petition came to be disposed of, isn't it? The one where you filed a review, it was disposed of.
Yes, that it is.
You produce that order if you have.
Lordship.
So that we can carry it to the logical end.
Lordship, I'll inquire.
Heard counsel for parties. During the course of the hearing, it was submitted by the learned government counsel that the order by which the petitioners were shown to be regularized by the order dated
I think
21/10/2005 had subsequently been cancelled by the government. However, although the averment to that effect is reflected in the affidavits filed by the department.
But in this case, no affidavit is in file.
In the review petition, not.
In the affidavit filed in connected matters. Affidavit filed in connected proceedings, which has already been closed. And no affidavit having been filed here, we permit the respondent authorities to produce a copy of that order before the court. In order to enable the court to pass consequential orders. What are these?
I have given some judgments and written arguments.
Judgments for what? For what purpose?
Regarding my lord, reversion, I have given some decision, my lord.
What are these relevant here? It's a question of-
They are stating that the regulation order they have recalled. Then they cannot recall that order, my lord, just like that, my lord. Regarding salary and my lord, regulation part, my lord.
Then what a climate of already very. Like yeah, please. December 30, I'm sorry, January 30.
As part of my lord.
List again on 30 January. January.
As part of my lord.
Part.
Abla.
Bless.
This case, my lord, no affidavit has been filed, my lord.
Hmm?
No affidavit has been filed, my lord.
What has been
Only
done?
CL 1711 was the last order, my lord.
No affidavit.
Matter pertains to, my lord.
Any affidavits you want to file or not?
My lord, here accountant general, they have to mainly.
Who's
That
for the
is-
accountant general?
That is their impugn order, my lord.
Some amount already recovered from the retirement benefits, my lord. 5,46,43,000.
The finance is also supposed to file an affidavit as per the last law.
Awaiting the instructions, my lord.
The Mr. K.R. Patgiri for the petitioner, the respondent counsel, Mr. R. Dhor for PWD, Mr. H. Olia, Mr. R. Borpuzari for Finance Department, reduce their prayer for filing necessary affidavit. Let this matter again be listed on 30 January, by which time the affidavits be filed without further delay.
Obliged.
Title 50.
I think.
None appears.
Second 30.
Yes,
Worship, this IA has been filed for seeking the, well, Lordship, inadvertently, we have not included in the prayer for challenging the order dated 1/8/2025 passed by the Director of Land Records and Survey in appeal number 30 of 2023.
no, you are filing this IA for modification of
For
the
the
order
amendment
dated.
of the prayer portion, your Lordship,
Huh?
for the prayer of the amendment of the prayer portion
In
in
the-
the writ petition, your Lordship.
So, but look into your post title, you are praying for amendment of the prayer in pursuant to the order dated so and so. There
Yes,
is
your
no,
Lordship. Where your
Alright.
Lordship, by order dated 22/0.
any objections?
Lordship.
I heard counsel for parties, this IA has been filed seeking amendment in the prayer portion, in the prayer of the writ petition, being WPC 4765 of 2025. So, learned counsel for the petitioner. The applicant submits that by oversight, the effective prayer was not incorporated and therefore this IA has been filed. It is submitted that the following prayer was required to be incorporated in the existing, in the writ petition which was filed. Which prayer you want to add? Page number 9.
Yes, your Lordship.
Page 9.
Yes,
9
page
and
9,
10.
your Lordship.
9 and 10.
Yes, your Lordship, that in the writ petition, that would be paragraph 4 in the prayer.
That's right, but you want to add this prayer.
Yes, your Lordship.
Like page number 9 and 10, added prayer, added interim prayer. We expect the opposite parties are represented by Mr. J. Hendik appearing for the Revenue Department and MS M. Bhattacharya for the District Deputy Commissioner, Additional Deputy Commissioner, Additional District Commissioner.
Even the lordships,
Who's for the petitioner? Who's respondent 5?
respondent 5 notice, I think one notice.
Yes, the respondent number 5.
Director of Land Record was not made a party in this case. But they are challenging the order of the Director of Land Record.
None represent respondent 5 as notice in the petition has not been issued with me. But considering the prayers made and also considering that no objection has been raised by the respondent counsel, please I stands allowed. Petitioner applicant is accordingly permitted to amend the prayer in the writ petition WPC number so and so. Accordingly, I stands allowed disposed of. Petitioner will file amended post title within 2 weeks from today.
Even the lordship, my lord, that they are challenging the order of Director of Land Records. Appellate order, my lord, they have to go for the, my lord, 162D.
We'll examine it. Let the amendment come.
Lordship.
After
And
that,
even then, my lord, that Director of Land Records has not been made a party.
you raise these objections in the writ petition.
Lordship, lord.
The amended post title be filed within 2 weeks.
Yes, your Lordship.
Item 26.
It'll kill, 31. None appears. Passed over for the day.
Thirty-one.
May it please your Lordship, the matter may be kindly taken up after some time as the engaged counsel is on length in court 23. After some time, ma'am.
All right.
Obliged.
Listen, guys.
Supplementary list for orders having.
May I please, your lordship, in this matter, my lord, I am seeking a little accommodation, my lord, to file my affidavit
My lord,
on behalf of finance department.
yes, sir, the matter was heard, my lord. And my lord, it's a cover case. My lord, already two judgment has been passed from the same, my lord, list of, my lord, regulation. Your lordship, go through page 54, my lord, of my additional affidavit, my lord. Page 54, my lord.
Yes.
My lord, my serial number is 11, Babulal Burman, my husband name. And serial number 12 is one Haya Nanpu, and serial number 20 is one Bijon Hafila. My lord, this honorable court has already passed order, my lord. These two orders, my lord, I have placed.
Yes, Mr.
Similarly,
It may appear to be similar, but on facts, my lord, we have to file our affidavit.
facts also say.
Why don't you go through the orders? We'll take it up after a while.
No, my lord, I have already gone through the orders.
You have gone through.
Yes, my lord, I want to file an affidavit.
You want to file an affidavit.
Yes.
Heard counsel for parties. Notice is issued.
Yes.
Notice issued. The respondents are permitted to file their affidavit as prayed for. Mr. Sokar, the other end, counsel, Sokar, counsel for the petitioner on the other end submits that similar orders have been passed by this court, by coordinate benches, and this writ petition can also be disposed of in terms of such similar orders passed. The said submission, however, is objected to by the counsel for the respondent accordingly. Let this matter be listed again on 2nd of February.
Obliged.
I'm so obliged.
Next is for admission, against traffic fire.
Taking clearance of defects. Yes.
Yeah, please, your lordship, this matter may kindly be taken up for 2 weeks, your lordship.
The request made by the counsel for the petitioner and matters then to be listed again on 2nd of February. Yes.
May it please your lordship, in this matter, my lord, respondent number 3 has filed one affidavit in opposition, my lord. We want to file and reply to that, my lord.
Lordship, I'm
So
appearing
some
for,
time may be given, my.
I'm appearing for respondent number 4. I'm also praying for some time for filing my affidavit in opposition, Lordship.
Mr. So-and-so, learned counsel for your Mr.
Upadhyay.
As Upadhyay, learned counsel appears for the petitioner to file, praise for filing a rejoinder to the affidavit filed by.
Respondent number 3, my lord.
Where is the affidavit? It's not here.
It be filed on 13/11, Lordship.
It's not
Yes,
here.
I have a copy, my lord. I was served with a copy.
You may have been served, but it has to be filed to be recorded. We don't know. Who's for? Filed by whom?
Respondent number 3, Lordship.
Who's appearing for 3?
Lordship, I am appearing, Lordship.
You filed it?
Lordship.
Commissioner of Income Tax.
No, Lordship, Secretary present.
Huh?
Labor and Employment Department.
Very
Lordship.
good.
Labor and
This is
Employment.
ours.
Item number?
36.
36.
Bogapani Tea Estate.
No. This is something else.
Petitioner is Bogapani Tea Estate, my lord.
No, sorry, your matter is not listed. The matter which is listed, before the court is not shown in the list. No order is required. Home file.
30, I'm 36.
36.
Yeah.
Oh,
No, the numbers are same. but
years are different.
Yes, sir.
This number is
5687.
568724. Matter which was listed was 568724.
Ours is 25.
Deeply obliged.
Item 37.
My lord, this is for the appointment of arbitrator.
Who's for the
And
other side?
he was there, my lord. Your lordship may kindly see the arbitration clause, my lord, at page 55.
Call for the other side because in the absence of that.
Yes.
You will inform me after some time.
After some time.
After some time.
After some.
39.
It may be passed over for the time being, my lord,
For the day.
for the time being.
Forty.
Lordship, consent from Mr. M.K. Bhattacharjee has been received.
In deference to the earlier order dated 4/12/2025, the notices were served, the copies of the order was placed before the prospective arbitrator, Mr. M.K. Bhattacharjee, retired district and session judge.
But I think the other
Bhattacharjee
advocate,
has submitted the written declaration under section 12(1). And accordingly, the same is available on record. Any objection to this? No.
Well, there was one more arbitrator.
there were two arbitrators.
Two arbitrators. my lord.
Your lordship had appointed three panel allowed. M.K. Bhattacharjee has given the consent. However,
However, the second arbitrator appointed by the court.
Ajay Chandra Bardoli.
Ajay Chandra Bardoli's consent is not yet available in.
It is not on record.
Accordingly, the matter stands deferred. We listed again. January 21st?
Yes.
21st.
21st. Obliged.
We will release for building item 50.
Last time they shown the judgment of Honorable Justice Michael Milo on the basis of two judgments, NTPC and Dolia Milo. NTPC Milo and Dolia Milo. These two judgments have been overruled by the subsequent judgment of the Supreme Court. I've given the list of judgments, my lord. They have to satisfy my lord now. That is 2025 one SC.
Was overruled?
2025 one SCC 502, that number 5 and number 6, my lord, 2025 2 SCC 192.
It overruled which judgment?
The NTPC and Dolia judgment, that's referred by them.
Yeah.
On the basis of which the Honorable High Court has passed the order, my lord. Lordship may see that 2000, I have given that judgment, 2025 to SCC. First judgment, Lordship may come to page 193, my lord. that NTPC, my lord, versus SPML Infra Limited.
You are referring to 25-1. 2025-1 SCC
Yes,
502.
yes, first, my lord, 25-2 SCC, my lord.
Okay.
Okay, 25-1 SCC, my lord.
Which judgment?
25-1 SCC and 25-2 SCC.
Which
both the-
one are you referring now?
Now, my lord, 2025-2 SCC, my lord.
2 SCC. Goki.
Yes, yes.
Yes.
Lordship made second page, my lord. The judgment referred by NTPC versus so-and-so held overruled, my lord. And then Vidya Drolia is a partly overruled. Lordship may come to para 18, my lord. In a recent married, my lord. In a recent pronouncement relying on the Constitution bench judgment of this court in interplay between arbitration agreements under so-and-so, in read this court, SBI General Insurance Company Limited versus Krish Spring summarize the law on the scope of standard of judicial scrutiny that an application under section 11(6) of 1998 Act can be subjected to. The relevant parts are produced below so-and-so. In view of the observations made by this court in interplay between so-and-so, it is clear that the scope of inquiry at the stage of appointment of arbitrator is limited to the scrutiny of prima facie existence of the arbitration agreement and nothing else. For this reason, we find it difficult to hold that the observation made in Vidya Drolia and adopted in NTPC Limited SPML Infra Limited that the jurisdiction of the referral court when dealing with the issues accord and satisfaction under section 11 extends to weeding out expressly non-arbitrable and frivolous disputes would continue to apply despite the subsequent decisions in so-and-so. Para 128. We are also of the view that expressly frivolity and dishonesty in litigation is an aspect which the arbitral tribunal is equally, if not more, capable of decide upon the appreciation of the evidence adduced by the parties. We say so because the arbitral tribunal has the benefit of going through all the relevant evidence and pleadings in much more detail than the referral court. If the referral court is able to see the frivolity in the litigation on the basis of bare minimum pleadings, then it would be incorrect to doubt that the arbitral tribunal would not be able to arrive at the same inference. Most likely, the first few hearings itself, with the benefit of extensive pleadings and evidentiary material. The scope of inquiry under Section 11 of 1990 Act is limited to ascertaining the prima facie existence of an arbitration agreement. In the present case, the High Court exceeded this limited scope by undertaking a detailed examination of the factual metrics. The High Court erroneously proceeded to assess the auditor's report in detail and dismiss the arbitration application. In our view, such an approach does not give effect to the legislative intent behind the 2015 amendment to the 1996 Act, which limited the judicial scrutiny at the stage of Section 11 solely to the prima facie determination of the existence of an arbitration agreement. Then 20 that Krish Springman referred, my lord, then para 21. Before we conclude, we must clarify that the limited jurisdiction of the referral court under Section 11 must not be misused by the parties in order to other parties to the arbitration agreement to participate in a time-consuming and costly arbitration process. This is possible in instances including, but not limited to, where the claimant canvasses the adjudication of non-existence and malafide claims through arbitration. Now, conclusion is there, my lord. The existence of the arbitration agreement in clause 18.2.12 of the MSA has not been disputed by the respondent. The question whether there exists a valid dispute to be referred to the arbitration can be addressed by the arbitration tribunal as a preliminary issue. So the next judgment, my lord.
21 is against you.
No. So, but if the lordship may see, it has to be take the preliminary issue. But if at all there is a this 20% or whatever, that has to be taken as a preliminary issue, then it has to be decided by the tribunal itself. Before the tribunal, not before the High Court, my lord. But that what the NTPC and Dorio judgment has
That is
said.
what 21 is said.
Before we conclude, we must clarify that the limited jurisdiction of the referral court under section 11 must not be misused by parties in order to force the other parties to the arbitration agreement to participate in the time consuming and costly so and so. This is possible in the instances including but not limited to where the claimant canvasses the adjudication of non-existent and malafide claims through arbitration. The next parameter, with a view to balance the limited scope of judicial interference of the referral court with the interest of the parties who might be constrained to participate in the arbitration proceedings, the arbitration tribunal may direct that the cost of the arbitration shall be borne by the party which the tribunal ultimately finds to have abused the process. Suppose if I abuse the process, I have to bond the thing. Having that said so, it is clarified that the aforesaid is not construed as a determination of the merits of the matter before us. The arbitration tribunal will rightfully equipped to determine. So it is the arbitration tribunal who has to decide. The conclusion, the existence of the arbitration agreement clause 18.2 MSA has not been disputed by the respondent. The question whether there exists a valid dispute to be referred to arbitration can be addressed by the arbitration tribunal as a preliminary issue. As a result, it was allowed. Now, the next judgment, my lord. Lordship, you see here also, my lord, page, internal page, my lord. The second page, my lord. The judgment where it is referred. The partly overruled this NTPC that is held partly overruled. So then Dorolia is also partly overruled, my lord. This two judgment was delivered on the same day, my lord. Now, lordship may come to the para 38, my lord. The very bench in Arif Azim commit married para 38.
Para
38.
38.
This Vidya Dorolia has been discussed, my lord. Then the next judgment, my lord. This very bench in Arif Azim Company Limited versus Aptech Limited was concerned with the following two issues while deciding an application for appointment of an arbitrator under section 11(6) of 1996 Act. First, whether the Limitation Act 63 is applicable to an application for appointment of arbitrator under 11(6) of 1996 Act. Second, whether the court may decline to make reference under section 11 of 1996 Act where the claims are explicit and hopelessly time barred. Now, para 41, my lord. However, subsequently very important observations were made by a 7-bench judge of this court in interplay in between so and so. In regarding the scope of judicial interference at the section 11 stage with the view to give complete meaning of legislative intent behind the insertion of section 11(6)(a) of the 1996 Act, the court referred to the statement of objects and reasons of 2025 Amendment Act and opined that same indicated that the referral courts shall examine the existence of a prima facie arbitration agreement and not other issues. At the stage of appointment of an arbitrator, the other issue would include the examination of any other issues which has the consequence of unnecessary judicial interference in the arbitral proceedings, the relevant observation, so and so. Then the 2015 Amendment Act was discussed, my lord. Then lordship will come to para 42. In light of the in the last para of the one that is internal 135, my lord. In so far our observations on the second issue are concerned, we clarify that the same were made in light of the observation made by this court in many of its previous decisions, more particularly in Vidya Dorolia and NTPC. However, in the case at hand, as is evident from the discussion in the proceeding parts of this judgment, we have had benefit of reconsidering certain aspects of the two decisions referred to above in the light of the pertinent observations made by a seven-bench judge of this court so and so. Then 136. Thus, we clarify that while determining the issue of limitation in exercise of powers under section 11(6) of the Act, the referral court should limit its inquiry to examining whether section 11(6) application has been filed within period of limitation of 3 years or not. The date of the commencement of limitation period for this purpose shall have to be construed as per decision of Arif Azim. As a natural corollary, it is further clarified that the referral courts at the stage of deciding an application for appointment of arbitrator must not conduct an intrinsic evidentiary inquiry into the question whether the claims raised by the applicants are time-barred and should leave the question of determination by the arbitrator. Even that two questions were there, my lord, whether a limitation act will apply or not. And second thing, my lord, that who will decide this issue, my lord. So for the second issue is a concern, the Supreme Court said the arbitrator has to decide the issue, my lord, even though limitation has been taken. Then para 43. Therefore, while determining the issue of limitation in exercise of powers under section 11(6) of 1996 Act, the referral court must only conduct a limited inquiry for the purpose of examining whether 11(6) application has been filed within the limitation period or 3 years or not. At this stage, it would not be proper for the referral court to indulge in an intricate evidentiary inquiry into the question of whether the claims raised by the petitioner are time-barred. Such determination must be left to the decision of the arbitrator. Now, thereafter also, my lord, 44, my lord. After all the scenario, whether the referral court is able to discern the frivolity in the litigation on the basis of bare minimum pleadings, it would be incorrect to assume or doubt that the arbitrary tribunal would not be able to arrive at the same interference, especially when they are equipped with the power to undertake extensive examination of the pleadings and evidence adduced before it. As observed in Krish Singh, the power of the referral court under section 11 must essentially be seen in light of the fact that parties do not have the right to appeal against the order passed by the referral court under section 11, be it for either appointing or refusing to appoint an arbitrator. Therefore, if the referral court devolves into the domain of the arbitral tribunal at the section 11 stage and reject the application of the claimant, we run a serious risk of leaving the claimant remedialess for the adjudication of their claims. 46. Moreover, the courts are vested with the powers of subsequent review in which the award passed by the arbitrator may be subject to be challenged by any party to the arbitration. Therefore, the courts may take a second look at the adjudication done by the arbitral tribunal at a later stage if considered necessary and appropriate in the circumstances. So lastly, my lord, para 53, my lord. The existence of the arbitration agreement as contained in clause 13.10 of the shareholders agreement is not disputed by either of the parties. The submission as regards the claim of the petitioner being expressly time-barred may be adjudicated upon by the arbitral tribunal as a preliminary. So, my already before this judgment, my lord, the Bihar State Food and Civil Supply judgment has come, my lord. So that has been that's already placed in, my lord.
Yes.
That's no, Bihar, that's the para 27 is the most important one. Para 27, my lord. Bihar. That managing director Bihar State Food and Civil Supply, para 27. After all discussing, my lord, lastly they came, the curtains have fallen. Courts exercising jurisdiction under section 11(6) of section 8 must follow the mandate of subsection 6A as interpreted and mandated by the decision of this court, and their scrutiny must be confined to the examination of the existence of the arbitration.
Yes.
There's another judgment, my lord, that Office of Alternative Architecture, my lord. There also, my lord, it is held that way, my lord, that
Where is the judgment?
lordship has given, my lord.
They're given.
Yes, my lord. That is number 3, my lord.
No, that is the list, but it doesn't contain the judgment.
Civil Office of, no, that is there in the file, my lord.
Hmm?
Okay, to look.
Oh, yes. 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 Which paragraph?
Paragraph, my lord, the judge 6, my lord, 6, 7, 9, 10, and 12. 6, my lord, marine, my lord.
Yes.
The short question that falls for our consideration is whether, while exercising power under Section 11 of 1996 Act, the court has to confine its consideration as to the existence of an arbitration agreement between the parties, if so, whether it would be permissible, while exercising its jurisdiction under Section 11 to hold that some of the claims raised are non-arbitrable or fall within accepted category. Subsection 6A of Section 11, which was inserted 3 of 2016, effect that 2310 makes it clear that while considering an application under subsection 456, the Supreme Court or High Court, as the case may be, shall, notwithstanding any judgment, decree, order of any court, confine to the examination of existence of an arbitration agreement. 9. The statement and object of reasons of 2025 amendment with reference to insertion of section 6A, that is, my lord, 6A is referred. And 10, the significance of the use of expression, not other issues in the statement and object and reasons of the 2015 amendment was noticed by a 7-bench judge in the court so and so. It was observed the above extract indicates the Supreme Court or High Court at the stage of appointment of an arbitrator shall examine the existence of prima facie arbitration agreement and not other issues. These other issues not only pertain to validity of the arbitration agreement, but also include any other issues which are a consequence of unnecessary judicial interference in the arbitration agreement proceedings. Para 12. As the above decision has been rendered by a 3-bench judge of this court, after considering the 7-bench decision of this court in interplay supra, we are of the view that the respondent cannot profit from certain observations made by the 2-bench of this court in Imar supra. In our view, therefore, the High Court fell in error in bisecting the claim of the applicant into 2 parts, one arbitrable and other as non-arbitrable. When it found arbitration agreement to be there for settlement of dispute between the parties, the correct course for the High Court was to leave it open to the party to raise the issue of non-arbitrability of certain claims before the arbitral tribunal, which, if raised, could be considered and decided by it. The appeal is therefore allowed. The order of the High Court, to the extent it includes the claim number so and so, referred to paragraph so and so, set aside. The parties are, however, at the liberty to take necessary plea of non-arbitrability of certain claims before the arbitral tribunal, which would decide the same without being prejudiced by any observation made by in the order of the High Court. This order, sir. So that is the.
Yes. Mr. Goswami.
My lord, all the judgment, my lord, produced by my colleague, my lord, is in all the judgments that it is said that this honorable court can look into the existence of an arbiter. All judgments. And my lord, my precise submission is that once they cross the, my lord, there are 4 arbitration petitions, my lord. When they crossed my lord, the bar of 20%, my lord, the arbitration is, the agreement is not.
Essentially, what you're saying is that out of these claims, one party is arbitrable, other party is not arbitrable.
Not arbitrable, no. All are arbitrable, my lord. My lord, they can come with 10 claims, my lord.
Arbitrable subject to falling within 20%.
No, my lord.
So
But my lord, I am not talking about arbitrability, my
No,
lord.
no.
I am not talking about arbitrability.
You're saying that once it crosses 20%,
my lord,
this agreement cannot be accepted to be an agreement between the parties.
Yes, my lord.
And thereby,
My lord.
those claims become non-arbitrable.
Non-arbitrable, no, my lord.
no arbitrability, my lord, I will not go into the
You are
arbitration.
going
Once,
to
my lord, the 20% threshold crossed, my lord,
Mr.
there is no
Gupta,
arbitration agreement. my lord.
make arguments for the sake of making arguments.
My lord, I'm
There are
position, my lord.
judgments of the cases, the Supreme Court, which are binding, you have to interpret. You
My
can't
lord, my lord,
interpret
my
a
lord,
judgment.
my lord, this is all,
You
this
can't
is what, my lord,
interpret, you can't interpret a judgment.
my lord,
Either you accept a judgment or you don't accept.
my lord, this is a conditional arbitration agreement. my lord.
Maybe.
My lord,
Let the
and my lord,
court
I'll
decide.
show from this judgment, my lord, Honorable Supreme Court, my lord. It is, my lord, reported in 2018, 6 SSC 534, my lord. Well,
All these judgments are, these judgments which are referred to by the petitioner are subsequent judgments.
my lord.
Have you
My
gone
lord,
through the judgment?
but my lord, regarding my lord, conditional, this is regarding conditional
That is
arbitration
also
agreement.
conditional.
Conditional, my
Why should the, once the arbitration agreement is there,
my lord.
whether this 20% needs to be added on individually or in total is an issue to be decided by the arbitrator.
My lord, please kindly.
Your
my lord,
once
kindly.
your argument is that 20% has to be in total,
My-
and they can come for arbitration only once.
No, my lord.
This is what you are.
No, my lord. My lord, kindly see, my lord, kindly come to page 125 of the, my lord, but arbitration petition. there. Page 125.
One twenty-five.
My lord, 125, my lord. 125.
125, yes. Yes.
My lord, the language is very clear, my lord.
Let it be interpreted by the tribunal. Why are you asking
No, my lord,
the court to-
there is a, my lord,
Is there an, is
yes,
there
my
an
lord,
arbitration
my lord,
agreement or
yes,
not?
it's
Is
there.
there an arbitration agreement or not?
No, my lord.
Is there an arbitration agreement or
My
not?
lord, no arbitration agreement, my
So
lord.
we record it.
My lord, kindly,
Process.
my lord, last, my lord.
No.
Last
We have
line, my
given
lord.
you enough time.
My
You
lord,
wasted
last
time.
line, my lord, kindly see, my lord. Kindly see the line, my lord, this line, my lord. 55.2, the provision of clause 63 and 64 regarding arbitration and other relevant clauses of the general condition of contract will not be applicable, and arbitration, my lord, this line is, my lord, and arbitration will not be a remedy for settlement of such claim, my lord.
That's right. Let the arbitration.
Precisely, my lord, it says, my lord, you cannot go for arbitration once you cross
Go to the
20%, my lord. So, my lord, I produce two judgments, my lord. Lordship may kindly see.
Then we'll continue in the second half.
My lord, my lord,
We'll come back in the second half.
my lord. Arbitration will not be a remedy for settlement of such issue. So, my lord, there is a clear bar for referring this dispute to arbitration. My lord.
What about the 20%?
My lord,
What about those disputes
My lord.
within 20%?
my lord, they have already been sent to the arbitration.
They have been.
Yes.
No, my lord.
No. Yes, my lord, we have our affidavit. Kindly see.
But there are, madam.
My lord,
Also, I
let me
can-
finish, my lord. I'm answering, my lord. They will get their chance to rebut, my lord.
No, of course, but show us where is.
My lord, in my lordship may kindly come to page 2007, 278, my lord. 278, my lord.
Two
278, my lord. I'll show the amount, my lord. What is the contract amount? My lord, thereafter I'll show.
Have you referred to arbitration or not?
Yes, my lord, refer.
Where?
My lord, kindly come to 281, my lord.
281.
My lord, I have the judgments also with me, my lord. My lord, yes, my lord, 281.
Yes.
My lord, dispute 2. Claim for payment of permanent strengthening work of trusses, 35.25 crore. The petitioner submitted a separate arbitration notice for this claim and has filed separate arbitration petition. My lord, already it was decided by the arbitrator.
Where is that? Is it decided?
Yes, my lord.
No, my lord.
What? No.
Different cause of action,
My
different
lord,
claim.
my
One-
friend was there, my lord.
The different.
And my lord, in dispute 5, my lord, I am.
No, where it is stated in your affidavit that it is decided already.
Ye-
You're only saying that he has filed, submitted separate arbitration notice for the claim and a separate arbitration petition.
Yes.
My lord,
What has happened to the proceeding?
my lord, My lord, I have this judgment, my lord. Kindly see, this is the judgment, my lord. I'm showing, my lord. Dispute 4. This is the judgment, my lord.
Dispute 2.
My lord, dispute, I can produce every judgment, my lord. This is this dispute 4.
Why have you not give a reference here?
My lord, kindly see, this is the judgment, my lord. by
No,
the
we are
honor-
not here to look into your judgments, Mr. Counsel.
My lord,
You have made a statement in your affidavit
my lord.
without any reference to the judgments and the particulars to be decided, and you are now trying to thrust this judgment under the nose of the court.
My lord, it is here.
What is the point in
My lord,
filing pleadings? What
kindly,
is the point in filing pleadings
My
if
lord.
these details are not?
my lord, it is here, my lord. Kindly see.
Where is it?
283, my lord. My lord. My lord, may I read, my lord, 283. In this regard, reference is made to the judgment and order passed by the Honorable High Court of Delhi in arbitration petition number
Why are you
20.
going to the judgment? We are asking you, according to you, you have submitted that this dispute 2, 3, 4, these are all referred to arbitration. They're under arbitration. They're within 20%.
My lord.
Is it a correct statement?
Yes, my lord.
Where have you stated, where have you made this averment?
My lord, they are themselves referring the claim number 6 and
My lord,
7.
let
They
them
have
deny,
not
my lord.
stated-
Let them deny, my lord, that these are not sent to the arbitrator.
First you place it
My
before
lord.
the court.
My lord, I'll show my.
You know, wasting time unnecessarily.
My lord, I am appearing, my lord, in dispute 5, my lord.
That is going on.
Well, that is going on, my lord.
Where have you
2,
stated
3,
it?
4, 5, my.
Where have you stated it? There is not a whisper in your pleadings to say that the disputes which they are now placing it by the way of this petition seeking a reference,
My lord.
part of it has already been referred and proceedings are undergoing.
My lord,
Lordship may see the notice of the dispute, my lord. We have clearly mentioned.
Don't make statements without proper instructions.
Page 236 may be seen, my lord. 236 and 246, that is claim number 6 and 7. That has not been decided.
Where is it? Where is it?
Right.
Even their reply does not indicate, madam, that dispute number 6 and
No,
7 has
my
been
lord,
decided.
yes, my lord, for a moment, my lord, if I agree, my lord, that we have not, let them, my lord, deny that 4 arbitration is going on, my lord. 3 arbitration already
First,
finished, my
it
lord,
is for
the 4th
you
is
to
going on.
assert.
My
It's
lord.
for you to assert.
My lord,
For them to
my lord,
deny.
my lord, this
Your
is,
assertion is not supported by proper pleading.
my lord,
Why are you
my lord,
insisting to
I'll
deny?
file an, my lord, this judgment is with me, my lord. If your lordship doesn't believe me, and my lord, I'll file an affidavit, my lord.
We are not the moral keepers of.
Well, since my lord, this is in,
You have been given opportunities to file your reply.
my lord.
You have filed.
My lord, that does not mean, my lord, they will
which are not
speak some false, make
You
some
point
false
it out before
statement.
the arbitral tribunal?
My lord,
You point out before the arbitral
no,
tribunal?
my lord.
Then?
My lord, we'll file an affidavit, my lord.
What
We'll
is the
file an
motion,
affidavit
madam?
by tomorrow, my lord. By tomorrow, my lord. Lordship may
Fine.
take up by
Fine,
tomorrow.
fine.
My lord, file.
Fine.
I'll file. By tomorrow, my lord.
My
And
lord,
be careful what statements you make.
My lord. My lord, my humble submission is, my lord, in dispute 5, my lord, I am appearing, my lord. That was 1, 2, 3, 4, my lord.
If
He
you are
appeared, my lord.
appearing, if you are appearing,
My lord, my lord.
this should have been.
Yes,
your
my lord.
first
That is my mistake, my lord. That is my mistake, my lord.
That the application under 11.6 is not maintainable because part of it is already.
My lord, my lord. That is my mistake, my lord.
Where have you
My
said
lord, my lord, that is my mistake, my lord. It's my-
Lordship, let me clarify, my lord. There were 5 disputes earlier, my lord. That is that they have also made a reference. Then dispute number 6 and 7 come, which is a different dispute, my lord. So this has not been adjudicated, my lord. So we are asking for appointment of arbitrator in case of dispute number 6 and 7. Up to 5, I understand, my lord, this is over. And the coordinated bench judgment also, lordship says the piece base 268, my lord. That para 4, my lord, as we earlier also read it, my lord. So this is 20% and above. The learned GCC appearing for the respondent has primarily assisted the claim of the petitioner company by stating that in view of the amount
You let
involved
them
in.
file a concise affidavit. You state everything that you want to state and bring it on record.
My lord, my lord.
When can you do it?
My lord, I did look at, my lord, can it be, my lord, 2 days left, my lord, only.
Bring it on 5th January.
My lord.
5th January,
5th January, my lord, I'm not there, my lord.
then
6th January, my lord.
6th January, all right.
Well.
6th January, you get your affidavit on record and you state exactly which of the claims are under reference to arbitration, what has happened, what is the state, who are the arbitrators, all particulars you give us.
But they should file their affidavit early, my lord, because we have to
You
respond.
must file it within 1 week.
My lord, my lord, I'll start to the senior counsel at his residence. My lord, I can assure you that. My lord,
Provided he is available in his residence during holidays.
my lord, if my lord, 1 week,
So
my lord,
don't make statements unless you are sure. How do you know he's going to be here in your
my lord,
residence,
that.
waiting for your affidavit?
My lord, yes, my lord.
You serve him by soft copy, email. Yes.
My
Heard Mr. A. Roy, senior counsel, assisted by Mr. E. Saivan, Mr. E. Goswami, then CGC.
No, my lord, railway council.
Standing counsel. Mr. Gupta is also appearing here.
Yes, my lord.
Then a CGC, but you mean during the course of the hearing, certain factual issues were urged to the court to the effect that portions of claims made by the petitioner for which reference to arbitration is sought for have already been referred to arbitration, and the arbitral tribunal is in session of these matters. So comes senior counsel for the petitioner, however, disputes this claim and submits that in respect of the projection made by the respondents with regard to how many disputes? 6.
Total 7, my lord. 5 is there.
7 disputes which are referred to in their pleadings. 5 of the disputes have been referred to arbitration.
Arbitration.
The
And this is
present
6 and 7.
pleadings pertains to seeking appointment of arbitrator with regard to disputes 6 and 7.
6 and 7.
6 and 7. Accordingly, the Railway Council will file detailed affidavit respect of all in respect of the disputes which are stated to have been referred to arbitration, and also point out the disputes which are yet to be referred to arbitration. Let this affidavit be positively filed within 1 week from today. Matter be listed again on 6th of January.
In fact, they have already stated that 5 of the dispute has been referred to at page 264 maybe matter. How come he says that
Let it file
the
it.
6 and 7 has been decided, my lord?
I have not said. Is it one? I don't know.
All right.
May it please your lordship. Lordship, in this matter, the issue is this: the person had been suspended on 9/5/2025, and as per the affidavit filed by them, the charge sheet was submitted on 5/9/2025 after a period of 90 days, and the review of the suspension order was 13/10/2025. And they are saying that Ajay Chaudhary is not applicable to them because as for that, I have filed an IA. I have filed an additional affidavit IA where I have stated a judgment of Karnataka High Court, where State Bank, where the same issue had come up and it was stated that Ajay Chaudhary is applicable and that has retained finality. And State Bank being a one unit, my lord, the judgment is applicable in a persuasive value and my lord,
Where is the Ajay Chaudhary judgment?
my lord, Ajay Chaudhary's judgment, my lord.
Is it here? Somewhere?
My lord, I have quoted the paragraph of Ajay.
Do you have the judgment with you?
I'm having a copy.
You have? Yes. Give it to the petitioner.
My lord.
Read the penultimate paragraphs.
Yes, my lord.
20, 21 or 22.
We therefore direct the currency of suspension order should not extend period of 3 months. If within this period, the memo of the charge sheet is not served on a delegate officer, employee, if the memo is served, a reason order must be passed for the extension of the suspension. As the case in hand, the government is free to transfer the concerned person to any department, any office within or outside the state so as to serve any local or personal contact that he may have and from which he may misuse from obstructing the investigation against him. The government may also prohibit him from contracting any person or handling records and documents till the stage of his having to prepare his defense. We think this will adequately safeguard a universally recognized principle of human dignity and the right to a speedy trial and also preserve the interests of Guwahati of the government in the prosecution. We recognize the previous constitution bench have been reluctant to quash proceeding on the grounds of delay and are set to limit to their duration. However, the imposition of a limit of the period of suspension has not been discussed in prior cases law and do not contrary to the interests of justice. Furthermore, the direction of the Central Vigilance Commission that pending a criminal investigation, the department are to be held in abeyance stands superseded in view of the stand adopted by us. So in my case also, my lord.
After that.
Yes. So far as the present case are concerned, the appellant has now served with the charge sheet. Therefore, this direction may not be relevant to him any longer. However, if so advised, he may challenge this suspension in any manner will be subject to judicial review. I absolutely understand, my lord. But in my case, my lord, the charge sheet has been filed after the period of suspension is over.
This is what is being said. Is
No, my lord, this thing has been distinguished. This thing has been distinguished, but this was applicable. This is not applicable. In my case, it will be different in this such, my lord.
In your case.
Yes, my lord.
If it was not served within 90 days, it falls in a different compartment.
Yes, my lord.
Now, even after 90 days, another compartment.
Yes, my lord.
Here is a case where it was served, but after 90 days.
Yes, and they had to review my suspension order. They did not review. They reviewed it at 10.
Now,
and
what is the notice that you want?
the suspension order, my lord.
Huh?
The suspension order. I want the quashing of the suspension order.
Quashing? No. Why have you filed the IA?
My lord, I had filed the IA because the departmental proceeding was been continuing, and that my lord was pleased enough to give us a protection that the department proceeding would continue, but the final order would not pass. And I had in this I have also brought this order, my lord, of the Karnataka's High Court judgment, my lord. Similar facts and circumstances, my lord.
What is the stage of the DP now?
Your lordship,
It's been continuing.
But not concluded.
Not concluded.
yet concluded.
So I'm just asking for revocation of suspension on the Ajay Chaudhary because
That will require hearing of the matter.
my lord, that would require, my lord, on the in a simple way, my lord, my lord's own judgments helps me in this case because my lord may see 5th May I was suspended. 90 days period is over. They charge sheeted me on September, and then they reviewed me on October. So my lord, the Ajay Chaudhary first automatically.
Right, suspension is another thing.
Yes.
But why are you asking for you are enjoying a stay order insofar as the inquiry is concerned?
No, I'm not
Is the
enjoying
inquiry.
The inquiry has not been stayed, my lord. It is
Not been stayed, but
yes.
No final order.
Yes. So, my lord, what I'm suggesting is that, my lord, because there's a violation of being I've been in an continuous suspension.
Your suspension is on a different compartment.
Yes, my lord.
And the departmental proceedings are separate.
Yes, absolutely.
Are you putting departmental proceedings to challenge in some proceedings?
No, my lord, I have when I filed this IA was only on because of this. But because, my lord, when the last occasion when the London Council had submitted here, that the suspension order was reviewed after on October. Thereafter, I filed the IA to bringing on record that if it is the position of law that after you have reviewed. So I'm just asking for setting aside of the suspension order because on the contrary of the Ajay Chaudhary judgment. And I may be kept in any position, my lord, wherever there is they feel that I'll have any hamper to the investigation. But because from May till December, my lord, I have been kept in suspension. And reviewing been done in October.
You are getting an interim benefit for which the foundational prayer is also not there in the writ petition.
My lord, my national prayer that I had
It's
given.
only with regard to
Suspension.
revocation of suspension.
Yes, my lord. And thereafter, what
But
happened?
you are enjoying an interim order in respect of the inquiry.
No, my lord, the order which my lord's order passed was on the basis that because last.
Correct it now.
So
You
my
allow
lord,
them to continue with the.
so my lord,
department proceeding.
on that aspect, my lord may then ask me for my reinstatement, my lord, because.
We'll examine that.
So my lord, in that case, my lord, if I again continue, because my lord has never suspended the department proceeding. My lord has only stated that departmental
That's
proceeding.
what it, but to
Yes.
what effect? It doesn't help you.
It just helps me that the department proceedings, even if they conclude, they cannot come with a final order. That's just a.
Because that is not even challenged in your petition.
Yes, I never, because of the letter dated 3/11/2025.
All right, we'll list it for admission then. After reopening, immediately.
My lord. On 6th, my lord, then. Or on 8th.
Matter again on.
8th.
On 8th.
My lord.
8th of January.
My lord, there is another WPC similar matter.
Wait, let us first deal with this order.
Yes, my lord.
WPC so and so. So far as the IA is concerned, that will conclude it. Why an IA is necessary?
My lord, let this order be kept till the next.
Why?
My lord.
What benefit you are getting?
My lord, as already, my lord, as.
What benefit are you getting?
Only benefit I've been getting is this, that they cannot, as to.
You're not even challenging this, the proceedings.
No,
the present writ petition.
So my lord, whether they would be in that aspect, my lord, Ajay Chaudhary is squarely applicable to them. They would.
Chaudhary is applicable or not applicable in respect of suspension.
Yes, my lord.
But the proceedings you're not even putting to challenge.
No, my lord.
And you are asking for an interim order where the authorities are now stopped from passing final order. Where are the basic prayers, foundational facts? Nothing is there.
No, may I just submit here, my lord? My lord, my 3/11/2025 calling me for.
You are going back to
Yes,
suspension.
yes.
itself.
No, not
Your
my,
case is-
not on my suspension, my lord. Not on my suspension. Not on my suspension. On my IA, there was an order of, there was a letter of 3/11/2025, which I brought it on record where they had called me for departmental proceedings. Lordship was graciously kind enough, after looking at their charge sheet and at their review order, Lordship was gracious enough to pass me this order that fine, we will decide the suspension order, but let the DP be continued and they would not draw a final conclusion. So Lordship may keep it till 8th. And if Lordship, if I'm reinstated, I'm reinstated. Anyway, I'm participating in a departmental proceeding. It is not that I'm not being.
Yeah.
Your Lordship, in the event the disciplinary proceeding comes to an end,
When is it likely to come to an end?
because it has now only started, Your Lordship.
All right, then it will not come to an end before 8th.
Yes.
Lordship.
List both the writ petition and the I on 8th for admission.
Or the interim to be there.
It is already there. It's not on a date-to-date specific, is it?
Yeah, till the next returnable date it was.
It's irrelevant now.
My lord.
Why do you want an irrelevant interim order?
My lord.
It makes you feel happy.
In a way, my lord. In a way, it helps.
It's not relevant.
My lord, in a way, it is, my lord.
There.
In a way.
They cannot conclude it before 8th.
Yes.
What benefit will
My
you
lord,
get
just
interim
on the aspect of just keeping in, my lord, or just on a pray, my lord.
that this interim order, if any, will continue till 8th.
Yes. My lord, there's a similar matter that is 5227 of 2025. Similar matter, similar ground. My lord, that was not listed today.
Similar matter filed by whom?
Filed by us.
Another petition.
Another
Another
petition.
petition.
Same.
Similarly situated.
Similarly situated. Same.
List this matter along with WPC
5227.
5227 on 8th. Yes.
My lord. 37.
Yes, Mr. Mehdi, what is?
My lord, this is for appointment of.
What about appointment?
Lordship.
You have your objections.
Yes, Lordship, Lordship.
You filed your objections.
Yes, Lordship, I already filed, Your Lordship. Long back, Your Lordship.
Why are you objecting? Where is that clause?
Clause, my lord, page 55. They failed to act as required under the agreement. On the ground of for future, my lord, they have no right to say anything at this stage.
Let us keep it for reopening, because even if we pass an order, we do not know whether you'll get it by today or tomorrow.
Yes,
We'll keep it on reopening 5th.
yes.
Matter be listed on 5th of
After
January.
BU.
No, what after BU vacation? 5th of January. An attempt will be made to dispose of the matter on the next date fixed. Pleadings are already exchanged. Yes.
This matter is non-settlement of my family pension claim. Non-settlement, non-finalization. This matter came on 12th, and that day could not be disposed of because of absence of the counsel for the AG.
Where is AG now?
Today he is also
No,
not
it's
there.
absent.
It is shown, it's reflected in the cause list.
Why is it not being settled?
Only reason to be that I failed to submit the decree of divorce.
Decree of divorce.
Decree of divorce.
Several correspondence were made, Lordship. She has failed to submit the same, Lordship.
Judgment is before the authority. Admittedly, government says I'm the legally wedded wife. Now they're insisting for decree without any force of law. There is no law which says decree.
But can you find fault with them for saying that they are asking for the decree also along with the judgment?
Decree will follow the judgment.
That's right. But whether it was executed or not.
Execute. You're not on execution, man. There is a decree of divorce of mutual consent.
Correct.
The judgment is before them. Our predicament is that we have applied. We are informed that this record has been misplaced in the family court.
That we will deal with it.
The question is whether there is needed under what law? There had to be some backing.
But once a judgment is delivered, consequential decree, if they ask for, can you find fault with them saying that it's not required by law to produce?
Under the pension rules, there is no provisions.
Pension rule is not there. They are trying to find out that you are not the wife. You are the divorced.
Yes.
What is this?
That
You are the
first,
divorced.
my husband married twice. I'm the second one. First marriage was dissolved.
That decree is not available.
Decree is not available. Judgment is there. Government admitted I'm the legally wedded wife in their affidavit. No dispute.
Where is the
Can you see their
Accountant General?
Can you see their affidavit?
Accountant General.
Affidavit filed by respondent number 6, Lordship. Kindly see that.
Can you see affidavit of R6?
11 paras.
Para 4, you can see para 4. That's the stand of the government, my employee. Running page 43. He had legally divorced his first wife so-and-so by judgment and order dated so-and-so of Principal Judge Family Court, Kamrup. And he married, that is the petitioner, as second wife on so-and-so. No dispute.
Where is that communication of the?
Para 6, can you see para?
Para 6, Lord.
Can you see para 6?
Oh.
Running page 45.
Yes. This is the accountant general affidavit.
No,
No,
it's
no, it's the state
a
government.
State government has affidavit. Lordship.
R6, my lord. SP, communication.
Official letters. are-
Accountant General returned a family pension case of so-and-so, stating that a family pension case could not be finalized due to certain observations, and requested to resubmit the same after correcting the observation in complete shape, along with the attested copy of decree of divorce, as well as other required document like NOK, etc. In this connection, several correspondence were made with upper so-and-so. The PAN Aadhaar card of so-and-so has already been resubmitted for resubmission of family pension case, but she had not been submitted a certified copy of decree of divorce to the office, for which the respondents could not be resubmit the family pension case. That is the only reason why it could not be finalized for so long.
What do you say?
Running page 46, Lordship, the correspondence are there, Lordship, A, B, C, and D, Lordship.
No dispute on that, man. Correspondence. Time to time, they've asked me.
No, but who has filed this affidavit?
Filed by the
It is
respondent of
SP
SP,
communication.
Communication.
Oh, that is the administrative department.
Lordship.
So.
AG is the, sir,
No,
they
why
are
are
objected
putting
by
the
the
AG?
AG, Lordship. They objected by the AG, Lordship, Accountant General. They have stated that for that some documents are required, Lordship.
Where have they
One of the
stated?
document is decree of divorce, Lordship. That's why that
At least
that case is pending, Lordship.
page 50 of that affidavit, Lords. These are the documents, 4 documents sought for by the AG.
AG, Lordship. 1, 2, 3, and 4, Lordship.
Where is the communication of the AG?
That was not.
It is not part of the
Not,
report.
not.
But they've referred here
Referred, Lordship.
as
Para
sought for
6,
by the AG.
para 6,
In page 50. Can you see page 50? It's a communication to the petitioner by the SP. R6. These documents as sought for by the AG Assam. They've also referred the letter, my lord. Letter number.
Letter number is there, Lordship.
Yes.
Well, let us have the AG.
Lordship.
Problem is they're not appearing, my lord. And because of that, for last 3 years, it could not be finalized. Reason being, no decree. No decree. But government has admitted I'm the second wife, legally wedded wife. Judgment is before that. They cannot adopt such a pedantic approach.
It is a car number.
Last occasion, D, what is it? Lordship.
In fact, my lord,
D, what is it?
some of the retail benefits like leave encashment, date come retirement benefit, it already been disbursed to me.
Each of the thing, each of the thing. Let us keep it for day after tomorrow,
Lordship.
or at least or tomorrow. We'll ask him to appear in the matter and see. Huh?
Day after tomorrow, Lordship.
Some of the retail
No,
benefits
day
already been
after is the
disbursed.
last day.
Last
So
day. Tomorrow.
let us see, because in all probability, the council will have no instructions. Or we keep it on 5th, immediately on the reopening. And meanwhile, you can serve a copy to one of the.
No, earlier occasion, the council appeared,
They appeared, but he's
some
not
of the
here.
occasions.
Not
Now, in
here.
the last two occasions, he was not there. My case is that some of the retail benefits, leave encashment, date come retirement gratuity, GPF, that already been sanctioned and disbursed to me. Sanctioned by the AG office. Can you see? Just
No,
just
but
for a
in
moment.
the absence, we don't want to.
I understand. The problem is that they are not appearing. I cannot drag them to the court. Shown there,
Then we'll have to issue notice to Accountant General's office. If they're
because
not-
they've already appeared, my lord. The council is there.
No, he's there, but he's not there, so we'll have to issue notice again, press notice to the Accountant General's office that their counsels are not appearing. Having
Is the
been arrayed as a party, they'll have to appear. So the other option is that we attempt to secure the presence of the Accountant
Obviously,
General.
obviously, my lord. That's why this
That
matter
we
is
can
posted
do is
today.
We can have it on 5th of
Can it be,
January.
let it be on 5th, my lord.
And you, both the councils will request you to make an attempt to inform one particular standing council, whoever you feel like. And give the person a copy of the writ petition. So that he comes back with his instructions on 5th.
Not sir.
Let it be on 5th. Let it be on 5th. then.
On 5th.
Even if we keep it tomorrow or day after, he'll probably come up with and say that he
Exactly,
has no instruction.
exactly. Exactly. His stand would be that decree is needed.
Heard counsel for parties, Mr. N. Nath, for petitioner, Mr. K. Chakraborty appearing for respondent.
1 to 6 lots.
None represents the Accountant General. Earlier, Mr. D. Bhattacharya had appeared representing the Accountant General on when the matter was listed on 21/3/2025. Subsequently, on 7/4/2025 and 7/8/2025 and 12/12/2025, the Council representing the Accountant General's name is not recorded in the order. Under such circumstances, we permit the counsel for the petitioner and also the counsel representing the respondent 1 to 6 to inform the Standing Council Accountant General that the matter will be called up again on 5th of January 2026. It is expected that the Accountant General, the Standing Council Accountant General, will be posted with the required instructions